We're live. Now, the question is, am I perfectly symmetrical? I think the computer needs to go here. That's better. Good evening, everybody. Let me just make sure that everything is good. Technically, everyone can hear my... What's the F for? Have I failed at something? Can you hear me? Okay. People are... When I see Fs in the comment section, now that I know what F means, I get nervous. Why is there another F? Let me just see if I can hear myself. Okay, people are messing with me. Okay, people. Good evening, everyone. I hope everyone is doing well. It's a beautiful, dreary November Sunday evening. It's going to be a good one tonight. It's going to be a good one because it's been another, my goodness, big week of election lawsuit dismissals, which is the big word of the week. The dismissals in Pennsylvania. What else? We've got the Flynn pardon. We've got, let me just check my notes on my phone. On the menu for the evening, the church lawsuit coming out of New York, an amazingly interesting Supreme Court decision. Surprising to see how split the decision is because we're going to get into it. Okay, so let's just do the standard intro caveats. Super chats, I want to thank everyone in advance. First, I thank you all in advance for the support. I do my best to get to all of them. I bring them up in as much as I can, bring them up so that people can read them, even if I don't get to read them out loud. If you're going to be miffed, if I don't read it out loud, don't do the super chat. It's going to make me feel guilty if you feel bad, and I don't want any of that. What else? None of this is legal advice. This is discussion. Some of you may not like the discussion sometimes, depending on what we're discussing, but it is, like, it doesn't get much more honest and unfiltered than Robert. I am honest, not so much unfiltered. I try to be nice even when I say things that are not nice. So, like when I reply to Mike Birbiglia on Twitter. Oh yeah, and then we're going to do the SCOTUS decision, Sidney Powell's lawsuit, Pennsylvania decisions, Mike Flynn pardon. What else do we have? Section 230 reform. It's going to be a big night. Let's just get to some super chats before we get too far behind. Could the reason Sidney Powell distanced herself from the Trump campaign, be to avoid conflict of interest with Flynn's pardon? So some people are saying, and we discussed it last week, that pardoning Flynn distanced Sidney Powell from the Trump campaign. Others were saying pardoning Flynn frees up Sidney Powell for her lawsuits. I at this point, I think it was just a question of pardoning Flynn because time is running out, and although there's another 2 months within which Trump can pardon, there's no need waiting to the end there in order to do it, because the outlook, whether people like this or not, Trump supporters, the outlook is, if you have your black ball there, your cue ball, the outlook is not great for Trump. I mean, there might be a long game, and it might be a super long game, 2024, after he's built a media empire to bring this movement back in 2024. But the immediate re-election long game is not looking all that great. So I think the pardoning Flynn was just out of necessity at this point. And then you can interpret whether or not it's to distance from Sidney Powell or to free her up so that she can focus more on the Georgia and Michigan lawsuits, which we're going to get into. Joseph Sorty says, the fraud can be proven all day long. It won't matter. If Trump remains president, regardless of how, it will cause societal meltdown of a new level. I think we can probably agree with that. And it due in large part to an overzealous media that wanted to create the reality so that if it ever turns out otherwise, it can no longer be written off as the reality. It's going to have to undo the reality that they built, and it's going to upset a lot of people. Nice shot, Viva. Which one? Oh my gosh, that basketball. Yeah. Check me out on Twitter if you haven't seen it. It was, it was those superstitious things that kids do when you throw a basketball. Are we going to break a new record this week? I don't actually think we are, just because it's impossible to break record after record. But I am just so happy with the turnout and involvement in these streams. It's not something I ever would have imagined. Mr. Frobot, don't read this or I'll be miffed. Touche. What do we got? Mike, here in Missouri, I was able to spend Thanksgiving with the family. Things don't seem so bad with loved ones. Here's some more support. Thank you very much, Nick. We had our Thanksgiving a month ago. And from what I've seen in the States, a lot of people are doing the Thanksgiving. I have to be careful what I say because YouTube might take certain things to be a public call to defy the rules and to do what you're told, as one Dr. Fauci said. What would worst thing that could have happened to Flynn with no pardon? So hypothetically, if Trump doesn't pardon and Trump is not president on January 20, whatever it is, 2021, a new administration comes in and they just continue with the prosecution. There would be no pardon, and it would just be continued prosecution under Sullivan, continued defense costs. What I loved, I saw someone on Twitter saying, we're going to get into it later, but someone on Twitter said, Democrats acting like pardoning Flynn is the outrage of the century when the Department of Justice themselves said they didn't want to prosecute or continue to prosecute Flynn anymore. It's politics. Oh, I'm not wearing that shirt, but whatever. You missed Bill Bambuga's 12,356 super chat. Lucas, thank you very much. Okay, what do we got? Otto Mata says, your video brought to my attention that the charges against Cuomo included that he had gerrymandered the orange zone to target and include Hasidic Jews. A lot of people overlooked that detail. That's what the Supreme Court concluded, and we're going to get into it when we talk about it. But yeah, it was getting to Birbiglia's analogy. His religion allows him to drive without a seatbelt and crash his cars into people, as though the churches and synagogues were asking for special treatment to destroy, as opposed to just equal treatment, not to be treated different. Not reading it, but yes, Charles, one of the three eternal truths. So what else is going on? While we wait for Barnes, where is Barnes? Let me just check my DMs. There's some amazing things. I'm going to talk about it with Barnes, but a lot of people don't fully appreciate in the Georgia situation with Raffensperger and this settlement agreement that Raffensperger entered into, in light of some lawsuits that had been filed by Democrat entities. It was called the Compromise Settlement Agreement and Release. A lot of people don't fully appreciate this settlement and release basically reformed or substantively modified the rules for mail-in ballots and signature checks. And Raffensperger, who entered into this, is now facing scrutiny for the results there, has made himself a player in this game, in that he was a participant in entering into a settlement agreement with Democratic parties, which are in theory hostile entities, at the very least adversarial entities in an election. He enters into a settlement with them, and we're going to get into it. And now I see Robert is in the house. Let me see here. Did I miss any super chats? What else is there? No legal advice. Let's see. Can Barnes go over why it's reported that Biden got 123 and 69 more votes in Wisconsin? I thought contented ballots were going to judge. We're going to get it to him. And why does no one have the power to preserve voting machines? Trump. Well, so this is another interesting thing that is one of the conclusions sought in Sidney Powell's lawsuit, which we're going to get into. Jason Savard says, the real issue that all patriots are concerned about, will any prosecutions ever take place? We demand that justice be done. I'm going to skip the last sentence. I don't want anyone misconstruing that. My prediction is going to be no, but no one's going to like that. I don't think. And there would have to be some serious evidence of systemic, overt coding fraud, whatever, for charges to be brought. We've seen the precedent for when charges are not brought, and it's not a good one. Where does Robert buy his suits? He wears suits so fine, he makes Sinatra look like a hobo. Well, let's ask him. Let's bring this in here. I'm just going to get one thing I want to bring out. How do I get rid of this? I want to bring out. Okay, here we go. Okay, let's do this. Bringing him in. Robert, how you doing?
Good.
Okay, you look like you're in home in Nevada.
Yeah, still in Las Vegas.
And let's see, actually, the intro that we haven't done in a while, is there anything you can discuss on the fronts of current lawsuits that we know you are acting in? I'm thinking Amy Cooper in particular. Has there been any public developments there?
Nope.
Okay. Now, so it's going to be a big night because there's been some decisions in the Pennsylvania suits. And I think maybe if we start with Pennsylvania, it's going to be the good way to go about it. Okay, I think there's going to be two things that are confusing maybe to some people. I mentioned it that there are non-Trump suits and there are Trump suits. There are state suits and there are federal suits. So this week, the big news over the weekend was that the federal suit, which is a Trump suit, was dismissed in appeal. And the state suit, which is a non-Trump suit, was also dismissed, and I believe it was an appeal. And I think people need to appreciate the distinction and the basis of the lawsuits and the basis of the dismissal. So starting with the federal Trump suit, coming out of Pennsylvania, which had some individual plaintiffs and the Trump campaign. The judge, and I did a video on it, basically said, you have no standing. The individual plaintiffs suffered injury in fact, but had no standing because they had to take their claims, what did they say, to the county level?
To other counties, sue different counties.
Okay, and the Trump campaign itself did not suffer injury in fact and therefore had no standing. What's the status of those lawsuits? They're going to the Supreme Court?
Yeah. I mean, ultimately, the different decision makers that will have a role in this are each state's Secretary of State, each state's governor, each state's state legislature, each state's state court system, the federal court system, and the United States Supreme Court, and then Congress. So you've got a lot of different decision makers who have different constitutional roles that are unique in the presidential election contest environment. And and I think currently there are pending state court cases in Wisconsin, Michigan, Pennsylvania, Arizona, Georgia, and Nevada. There are federal court cases out of Pennsylvania and that have now been filed, I believe, by Sidney Powell in Wisconsin and Georgia. The Trump campaign is only a known participant to the Pennsylvania federal case. It appears they're going to be going to Wisconsin state court proceedings though that goes through an election commission challenging various ballots. To that earlier super chat question, the reported numbers out of the Wisconsin recount are the uncontested numbers. There's a bunch of contested ballots that have yet to be adjudicated. So the media, of course, ran with the headline about what the uncontested ballots showed Biden with a greater number of votes. But the contested ballots are in the thousands and more than enough to constitute a majority. In addition, you have different groups suing. So you have the Amistad group that's suing in either state or federal court in multiple jurisdictions, mostly state court. You have the Sidney Powell group that sued already in federal court in Georgia and Michigan, and maybe adding additional states, including Wisconsin and apparently maybe Virginia, and maybe other states as well. You have election contests brought by Republican Party officials or people connected to them in Pennsylvania and in Arizona, and I believe soon in Georgia. So you have a lot of different cases in a lot of different courts in a lot of different places. And you have the Trump campaign going direct to state legislators in their Pennsylvania hearing they had this week, scheduled hearings for next week for Arizona, maybe additionally Michigan and Wisconsin and Georgia. There's requests that they hold hearings. So there's a wide range and constitutionally, everybody has a potential role. So the state legislators are given the direct power to choose how the president is elected. Once they create a certain procedure, the question is, can they delegate their powers to the Secretary of State, the governor, or to the popular vote? That's honestly an unanswered question for the most part. And the U.S. Supreme Court clearly has a role to play. The state Supreme Courts clearly have a role to play in adjudicating election contests. And then Congress itself is the ultimate barometer because Congress certifies the electors. And like one of the confusions out there is election certification versus elector certification. Election certification is just for which electors show up in an electoral college, but that's not always determinative because there's been extraordinary gaslighting and sort of blacklisting the memory holing the history of our Constitution and the country, that we have been through things like this before in different variations in 1800, 1824, 1876, kind of in 2000. And that, in fact, that there's arguments that the vice president has a role to play. I guarantee you, if the Democrat was in the vice president position, they would be saying they have a role to play because they could unilaterally determine the scope of it. And so to give people an idea of the time frame, where there's been a lot of misinformation out there by the media mostly about, oh, it's over, it's done, it's finished. If you don't win this suit, it's over. So none of that's accurate. The first part of frankly, for election litigation, the first part is the certification of the election prior to the electors meeting. Then almost all the states have some means of election contest provisions of one type or another. Those are just starting. They've just been filed in Arizona. I believe one was filed in Pennsylvania this week. There's more coming in Georgia. and there's an audit proceeding in Michigan, and there's an election commission contest about to proceed in Wisconsin, and there's already an election contest suit in Nevada.
So actually, explain something. I don't think a lot of people get this. I sort of think I get it, but the media tries to pretend that the certification is the end game, whereas in a great many cases, the certification is the starting point from which to litigate, because that's when the prejudice, so to speak, is formalized. So people think that certification is the end of it, where in fact it is the, what's the word I'm looking for? The switch that needs to be flicked in order for certain litigation to go ahead.
Yeah, it's the trigger. It's the firing gun. So you're generally not considered to have a injury that's worthy of an election contest, or in some cases even standing to bring suit in other contexts, until and unless it has been certified by the relevant elected state election official, which is usually a statewide official in the presidential context. And so that's what gives you the right to bring an election contest, usually between 5 and 10 days. Pennsylvania's had an unusual rule that required it to be brought within 20 days of the election itself. So but that's usually the trigger. So in most states, you can't file an election contest until the election has been certified, and your rights there are broad. You don't have to get over standing issues for the most part. You don't have to get over, mootness or latches or any of the procedural tricks that courts use to Pontius Pilate their way out of these issues. And you have broad remedy. To give an example, in Arizona, you have a right to inspect the ballots as part of an election contest. In Pennsylvania, in part, you have the right to inspect the ballots. In Georgia, you have the right to inspect the ballots. So you have discovery power, you have subpoena power. Now, everything's done on an expedited basis. Often, from the time you file, hearing can happen as early as 5 days to 10 days later. And so you got to amass your evidence fast. You got to move quickly. But in the Bush v. the only presidential case to go through the election contest proceedings of these kind of judicially created and state created remedies was Bush v. Gore. So Bush v. Gore was, and the other thing that's out there is you're hearing particularly sort of law Twitter claim that there's no federal issue for the U.S. Supreme Court to get involved in a lot of these state election contest issues. They clearly have never really read Bush v. Gore. They've never read the concurrence by Chief Justice Rehnquist. They had multiple grounds by which they chose to assert jurisdiction in that case. And they had multiple grounds by which they chose the remedy, because equal protection did not require they close the recount. Equal protection just required they change how the recount was being done. They said, no, you can't even go forward. Why? Because of the electors clause and because of the federal statute safe harbor provision. And they made broad statements that said if an election concerns the presidency, we always have jurisdiction, period. So if the U.S. Supreme Court wants to take the case, there's nothing limiting them from taking the Pennsylvania state case, the case that's going up to the Third Circuit, or any case from any state or federal court.
But so this is going to be the question. They say even if the Supreme Court takes up Pennsylvania, the question really was unequal. Let's say 14th Amendment violations because the unequal treatment in that certain counties had certain procedure, whereas other counties had different procedure. The argument is that some of the procedure for curing ballots was specifically targeted to Democrat counties, even though the judge doesn't think that was sufficiently clearly alleged in the suit. So even if it gets up to the Supreme Court and they adjudicate, Pennsylvania is not going to swing the election one way or the other. So what's the best case scenario? Even if it gets to the Supreme Court, and even if Trump prevails in Pennsylvania, it's a state-specific question that's not going to impact all of the other swing states. So how do they get past that hurdle?
So there'll be common issues of law to a certain degree. So the Supreme Court could take a combination of cases if they wanted. The second is if they still need to win in multiple states. So they need to win contests in Arizona, Nevada, Georgia, Pennsylvania, Wisconsin, Michigan, some combination of those six. But they have legitimate legal and evidentiary issues in all of them. And they're probably the weakest is Michigan, just because of the margin is bigger. But I mean, very tiny margins in Arizona and Georgia. And the strongest legal issues are in Pennsylvania, that those three deny Biden a majority and sends the election to the U.S. House. Or if they reverse and say Trump won them, then that would resolve it at that level. That's where all those issues are present. And the federal issue out of there's really three different cases pending out of Pennsylvania. The federal case brought by the Trump campaign, the state case brought by local representatives, And then the election contest that I think has been filed.
And it's a judge, I think. I noticed the plaintiff is the Honorable something in the state case in Pennsylvania. And I mean, if anybody's going to try to remember this, this is how it is. So in Pennsylvania, you have the contest suit, the federal suit, which is Trump. The question there is constitutional violations of equal protections. In the state case, let me make sure I don't screw this up. What was the state case now? I forgot. It had to do with, oh yes, challenging the act that related to mail-in ballots, Act 77, which was passed in 2019. The argument is that Act 77 is unconstitutional at the state level. The judgment coming out of Pennsylvania, and this is where we're going to get into this beautiful, sinister, annoying, demoralizing catch-22 of the legal world. The lawsuit was dismissed on the grounds that the vote has already occurred. People voted on the basis of the constitutionality of that lawsuit. And so too late, theory of the latch is you can't sue now and we can't grant you the relief because they've already voted. If you wanted to challenge the constitutionality, you should have done it before. The flip side to that, not to create a straw man argument because this is not the argument that's been used, but in other cases, they've said you have not yet suffered an injury. In fact, it's the reason why the federal suit was dismissed. And so you can't sue because you haven't suffered an injury yet. And typically in constitutional law, you don't just go around challenging laws because you want to. You have to have an interest in doing so. So this is the catch-22 where some are going to say, even if they had filed it beforehand, it would have been dismissed because there was no injury in fact. Now it's being dismissed because the injury is done fait accompli. So it's sort of this judicial catch-22. First of all, what's your take on it? And is it the same thing in the States? Like you have to wait for there to be an actual issue to challenge the constitutionality of a law?
So, yeah, I mean, the interesting thing with the state court case is so far the only place Trump has seen any potential remedy has been from state legislatures doing some hearings and talking about willingness to challenge the election, from some congressional members, and then particularly members of the House. But now even Senator Rand Paul is making some interesting comments. And then is state court level. So the state trial court, Pennsylvania trial court, rules that, in fact, it appears to be this election was in violation of the Constitution and enjoined certification. The Pennsylvania Supreme Court, that has made many, many strange rulings in this throughout this entire election period, didn't even wait for 24 hours to rush in and shut it down. And the Democrats were very aggressive, and they were the ones who came up with this latches theory, which I've dealt with in the election law context. And the Republican judges dissented on the latches issue, but said they didn't really want to get involved in setting aside the election, but did think there was a serious constitutional question that needed to be addressed. So the basically what is Pennsylvania's Constitution governs how absentee balloting can work. And, Uncivil Law did a presentation on it, and there's two different interpretations of Act 7 of the constitutional provision. One is that it's a floor that says these are the minimum requirements you have to make available for absentee balloting, but you can do as many more absentee ballot provisions as you want. The other is that it's a cap, that it's a ceiling, and that you can't do any more for absentee balloting than these. The better historical reference or historical context is the fear of absentee balloting being misused and abused is what informed those constitutional provisions. And I believe if they go back and look at the predecessor provision of the Pennsylvania Constitution, it was interpreted as a limiting principle, saying you can only allow for absentee ballots in this context. Otherwise, you have to amend the Constitution. Pennsylvania passed a law that did not amend the Constitution, but just allowed for massive absentee balloting to occur, what they called no excuse mail-in balloting. And it's really not into controversy that gave Biden his margin of victory. And so the question is that they were raising was this was clearly an unconstitutional method of voting. These votes should be thrown out. The trial court gave a very disciplined, thoughtful interpretation and was willing to make a brave position of let's hold off on certification until this gets resolved. While that was going on, the Secretary of State and governor were playing games, trying to get the judge not to enjoin the certification and then secretly certify on the side. That's the kind of nonsense Democrats are willing to go to. Whereas just like the Republican judges of the Pennsylvania Supreme Court, they're like, oh, we don't want to be, bashed. I mean, they're all weak. They're either weak. Now, it's not a coincidence that almost all these Federalist Society types, that three of the judges who've ruled against him in the federal side are all Federalist Society types, actually four, and three of the four were Trump appointees. on the federal court side. So this is the problem. This is, I use this as an opportunity to remind people the reason why some of us complain about the Federalist Society having a monopoly on federal judicial appointments and executive branch appointments, like Christopher Wray, another member of the FBI, another member of the Federalist Society, director of the FBI, and who's been completely AWOL during this whole thing. The just now is going to pick up documents from Matt Braynard to figure out what's going on. I don't expect any meaningful investigation to come of that.
A couple of people that asked, why isn't Barr involved? Why isn't the FBI involved? Why isn't the DOJ involved? Is there any good explanation? I mean, people are making the joke that the FBI got investigating a rope on a garage at an F1 hangar and is not getting involved here. Is there any good reason? Is there any logical explanation?
If they were serious, they would have been investigating this leading up to the election, because everybody knew. I mean, like I said, Democrats had been warning for 15 years. New York Times warned 10 years ago, or less than that, 8 years ago, that whenever absentee ballots increased, there would be massive fraud. They would have been investigating. I mean, this didn't take brain surgery. For example, a whole bunch of people were illegally registered to vote at mail drops in Georgia. You could figure, it took Matt Braynard a day to figure that out. It wouldn't have taken much time for the FBI to figure that out and to infiltrate those groups, figure out what's going on. They just chose not to. Instead, they were busy entrapping some right-wing or alternative social media types in a conspiracy plot against Whitmer that didn't exist except in the FBI's fevered imagination until they put it in the heads of these kids. So, the FBI is politically corrupted, has been all along, and a big part of the problem is the monopoly on legal appointments by the Federalist Society. It's a problem. It's if the U.S. Supreme Court can clearly get involved in this ultimately. If they don't, it will be an indicator that the wrong people were put on the bench. But we're already seeing signs of that. It was a Trump appointee in Georgia that came up with nonsense arguments. It was a Trump appointee that wrote the Third Circuit case with just nonsense arguments, frankly. Some of those are, like he said, if there's discrimination between counties, that doesn't matter. Well, that's exactly what Bush v. Gore said did matter.
It's an amazing thing, and just so everybody appreciates that, what the judge said, to dismiss it on a motion to dismiss, no evidence presented yet. It's a motion to dismiss. They're taking the allegations in the best possible light for plaintiff. The judge says it doesn't matter if counties have different ways of counting, so long as everyone within a county gets treated the same way. So you could appreciate that logic in the way you want. It doesn't seem like logic to me. That seems like mental gymnastics. And Bush v. Gore seemed to be on point, except that it was what was the difference? It was only one state as opposed to what was it? He said it was within the same counties in Bush v. Gore versus different counties in Pennsylvania.
And he's wrong, because one of the big issues was differences between the counties in Florida. So he's just lying, frankly, about what Bush v. Gore said. But again, this is a Trump appointee. This is another Federalist Society guy. This is who McConnell pushed on Trump. A bunch of judges who would betray him when he's needed the most. So that's why people gave me a lot of pushback on criticizing Federalist Society monopoly of appointments. Now they're going to witness it. This was a problem. This was always a problem. And now we're seeing the problem in live time. Because the other thing is, it'd be one thing if this judge had a sincere belief. The insincerity was reflected in some of his statements that directly contradicted precedent. But the other part was pot shots that were totally unnecessary, that were rhetorical and political and meant to be anti-Trump. So and again, he's only on that. He only has that power because Trump got suckered to putting him on there, thanks to Mitch McConnell. And notice Mitch McConnell is nowhere to be found. The turtle is hiding out somewhere. So this has been a building problem of the institutional Republican Party using the Trump presidency to put their own people in position of power who have spent 4 years undermining Trump. And now they're not even willing to. A Bush appointee would never have done this to Bush. All the Republicans lined up in lockstep for Bush, just like all the Democrats are lining up in lockstep against Trump at the judicial level. But Trump's biggest problem is that his own appointees are the ones not giving him remedy and relief, and often taking political potshots in the process and sometimes inventing new legal doctrines, other times just reiterating old bad legal doctrines. So going back to your first question, I used to call it, having done a lot of election lawsuits, because I got in the middle of this and saw the most ridiculous arguments being made. And so I started saying, okay, if I have no standing if I sue in spring, if I sue in summer, it's latches. I sue too late. And if, by golly, if I sue in fall, it's moot, totally moot. Well, why the heck didn't I sue earlier? Though if I sued earlier, they would have done what the Pennsylvania federal court, another Trump appointee, did to Trump and said, you don't have any standing because you can't prove the fraud would injure you yet. And now, of course, they file after the election, the related state representatives, and the Pennsylvania Supreme Court says, golly gee, why did you wait so long? So it's pure hypocrisy. It's meant so that you can never file suit.
And this is the thing now, hypothetically, no, I guess you could file again after if you sustain injury if they had filed before, and it sort of requires everyone to file before, during, and after, in the hopes that you don't miss one of those windows and then have it held against you. In the sense that, if you want to challenge the constitutionality, you have to wait for the damage to occur, and I think that's what one judge called it, injury in fact. So you couldn't sue before. Although I don't think they did, and I was trying to see if they in fact did, and it doesn't seem that they did.
They partially did. So they challenged, like the state action is challenging both the Act 77 as being unconstitutional and subsequent effective amendments by the Secretary of State as being unconstitutional, because she expanded even more who could vote absentee. And even the notice and cure opportunity, no signature matches needed to be imposed. You could canvass at different times than what the law provided for. Didn't require monitoring or didn't enforce it if it didn't happen. So they had those provisions too. The Pennsylvania Supreme Court pretended didn't exist. Those actions were partially brought in the federal court by the Trump campaign prior to the election, when it was partially dismissed on grounds that no standing existed because no injury happened, because it's purely speculative. You can imagine if let's say someone had brought the suit prior to the election. First question from the judge is going to be, how have you been injured here? You're saying that maybe people are going to use this to vote, and maybe that margin of victory will be that number of votes will be more than the margin of victory. Those are all maybes. That's speculative.
Or the question now, because my understanding was that Act 77 could be unconstitutional in that it modified state law without going through the legislature.
Oh, no, the Act 70, there's two parts to the challenge. Act 77 is that the legislature passed something that was unconstitutional, that they had to go through the constitutional amendment process to change the absentee balloting rules. The second part of the challenge is that on top of that, Act 77 was used by the Secretary of State and just amended it unilaterally without going through the legislature. And the issue that impacts is also part of the federal case, which is the electors clause. And Sidney Powell is also paralleling this in her claims, which is that if something wasn't constitutionally passed through the legislature, then that violates the electors clause that says the state legislature exclusively determines how the presidential electors will be chosen. So that's a separate, by the way, Bush v. Gore, they cited that too. All the law Twitter types and the media lawyers and Democrats are all pretending that part doesn't exist in any of these claims. They're also arguing from power, not from principle. I get people say, oh, look at how many times Trump has lost. And I point out two things. Bush mostly lost until the U.S. Supreme Court. He lost at the Florida State Supreme Court. He lost at the Federal District Court. He lost at the 11th Circuit Court of Appeals. Then he won on a state claim before the U.S. Supreme Court. And it's important that was a state claim. That was an election contest state claim. And that was from the Florida Supreme Court that they took a petition for cert. And they decided that it was under federal law. The Florida Supreme Court didn't address any federal legal issue. It was the U.S. Supreme Court decided to say unilaterally, this is a presidential election. It impacts the electors clause. The presidency almost always impacts federal law. The U.S. Constitution is almost always in play. And they were the ones who just asserted standing existed and jurisdiction appealed. So the U.S. Supreme Court will have no excuse, no legal excuse for not taking any case that they want to take. If they don't take it, it will be politics, not law. And that's the whole issue here. On principle, Trump has a very strong case on the law, a very strong case on the facts, in enough states that constitute a majority of the electoral votes to put the election into doubt and to send it to Congress, or to have state legislatures send in alternative electors. His vulnerability, his hurdle, his obstacle is politics and power. Those who make the decisions in this arena will want to do everything possible to not get involved. They will all try to play Pontius Pilate. A few will take pot shots at him because they are part of the anti-Trump constituency, even if they were appointed and put into positions of power because of Trump or won office because of Trump. That's how bad these people are, frankly. It's the reason why he needs a movement that's much wider, much broader, much stronger if Trumpism is going to mean anything more than a fun Twitter feed. And so the effect of it is that's his limitation. Now you're seeing, state court of Supreme Court justices, even though they didn't take up the case, they made significant points in Trump's favor about auditing the election, raised major, anytime he gets any court to say something happened here that was deeply wrong, that's advantageous to him, even if he doesn't get ultimate remedy, because it's documentary proof that he was right. And so the Michigan State Supreme Court justices are saying there's major problems. Pennsylvania trial court judge said there's major problems. Pennsylvania Supreme Court justices, concurring and dissenting in part, said there were major issues. And so that's good. And that's getting some momentum. The hearing he held was very effective for the court of public opinion in Pennsylvania. I think there's, they need to be cleaner and neater on their factual presentation and make sure there's not easily impeachable facts that they present. That's still a limitation, but that's all good. And I think that he made progress this week for certain. The highest number of people doubt this election than have ever doubted any presidential election in polling history. Now, if you went back to 1876, 1824, you might find, a greater percentage, but we didn't have polls of this kind back then. But you're seeing, I know Richard Barris, the People's Pundit, is going to be polling on this week. And what you're going to find from an honest poll is 75 to 80% of the country will say, yeah, of course you should check the signatures and audit the signatures to make sure no illegal ballots were cast.
Well, it's a no-brainer. I mean, it's a no-brainer, and why they wouldn't do it, or the fact that they're not doing it, is not being, the media is not making an issue of it. Actually, I just want to do one thing. I want to bring up Uncivil Law says, I appreciate the Class Away Barnes disagreed with me about Act 77's constitutionality. Very deftly done. And Nate Brody and Nick Recchietta disagree with Kurt. So in good company. And go ahead.
And his interpretation made a lot of sense. It's mostly what's been missing from the public dialogue is the context of absentee ballots. This has been the most criticized area of voting of any area over the last 100 years. And so since we invented the secret ballot, the greatest attack on the secret ballot is the absentee ballot, because it's no longer secret unless you have safeguards. And it isn't just that there was a mass of mail-in ballots in this election and that there's peculiarities at where voting took place. It's that they removed every single safeguard that was available. And they clearly didn't. I mean, Pennsylvania, they admit they didn't check the signatures for the most part. In Georgia, they're pretending they did. In Wisconsin, they allowed a whole bunch of people to claim to be indefinite, not custody, but basically indefinitely detained, if you will. And COVID was not a legal excuse. The legislature never said that could give you the right to an absentee ballot. So what happened was a bunch of counties just ignored the law and let a whole bunch of people vote as if they were indefinitely, like they were in a nursing home or in a hospital bed, when clearly that was not the case. That's one of the principal areas the Trump campaign is challenging. That's also where the lawsuit that's been filed, they filed an original petition in the Wisconsin Supreme Court to do that. I actually was part of filing one of those back for Nader in 2004. We got Nader on the ballot. Everybody said we couldn't do it. We did it, and we won in front of the Wisconsin Supreme Court because we were circumventing the corrupt Wisconsin Court of Appeals, who I still have some bitter grievances about, but that's another story. That was a very smart action by the Amistad Project of the Thomas More Society. The lawyer leading that is the former Attorney General from Kansas, so he's not a nobody. And they've hired Matt Brainerd and to incorporate his work in their suits. And I believe they're going to end up filing everywhere in the 6 contested states. There's a very good election contest filed by Adam Laxalt's associated groups. Again, Adam Laxalt was the Attorney General for Nevada. That's going to have an evidentiary hearing, I believe, this week, where they're going to get to present all the people who suddenly registered to vote at casinos in Nevada.
And this is another talking point, and some people are repeating it in good faith. Some people are repeating it in bad faith. I'm convinced that the Trump campaign has presented no evidence, despite having had 35 opportunities to do so. Sorry, I'm choking on my tongue here. He hasn't. I mean, setting aside the fact that those 35 suits that were dismissed were not Trump's. Even in the suits that he filed, they haven't presented evidence yet. They were dismissed on motions to dismiss for lack of standing and for questions that had become moot because the damage was already done. So it's just who was it? It was John Roberts, I think, who tweeted, there's absolutely anybody who pretends that there's evidence of voter fraud is delusional. It might have been the other way around. And I said, for you to say that means you're not even looking into it. There's a lot of prima facie evidence, and the evidence has not been presented in court for these reasons that people don't fully understand. And it just gives them the ammo to say, yeah, the lawsuits were dismissed, therefore they must be frivolous, where they really are dismissed on technicalities. But one thing, actually, I want to make sure that we talk about before I forget. In Michigan, you say that's the weakest case. I've been hearing a lot of projections that the voter turnout was 100% and more in many counties. And the rebuttal to that is those are just projections; they're not actual stats. And so I don't know how to make sense of that. What is the situation with the voter turnout in Michigan counties, and is it as high as 700% as I've heard reported in some places?
What it is it's the statistical source of data. So a lot of people are getting their data from the Edison Research Project that was associated with the New York Times, which got its data from other sources. And so you ultimately want to see what the final certification shows and the precinct level breakdowns. Now, some of these states have same day voter registration. So that's what can influence turnout. So a lot of that data is not yet confirmed from what I've seen. So the existence of anomalies of some sort has been documented. There's differences of opinion about what those anomalies mean or whether they're truly anomalous statistically, about whether certain standards apply. But I recommend people look at Matt Brainerd. He just focused on the provable components. So he just looked at, okay, let's look at people that lived out of state, who voted in a state. Let's look at people who are living at a place that's not their home because it's a mail drop that's illegal to register to vote in like that in states like Georgia. Let's look at, he was the one who ended up calling, and a person ended up appearing on Fox News who voted in Arizona, who said, I live in Tennessee. I never voted in Arizona. So he said someone else voted in his name. Arizona had certified the election without even investigating that question. That's part of the election contest that's pending. So so he went through and documented in each of those groups, sometimes by themselves, are more than the margin of victory in states like Arizona, Wisconsin, and Georgia. And then you aggregate them, and then they're more than the margin of victory in Pennsylvania. So and those are just the easily provable components. So he didn't even get into the data, didn't get into statistical anomalies, didn't get into turnout issues, didn't get into the timing of vote drops, none of that. Just said, look, we have groups who clearly either were not qualified to vote because they were out of state or because they were registered at a place they didn't live. And he's the one who started documenting unusual nursing home turnouts. If what you would look for if the FBI had been doing their job, you would look for things like unusual nursing home turnout. When you get one nursing home that gets 95% of the people in that nursing home vote, and the nursing home down the street, only 20% of them vote, you better at least do a signature match check, because that's a place where you have a bunch of ballots where one person could have control of them and one person could send them all back for the person. So knowing that almost nobody cross-checks that information. So the only check on that, because they removed all the others, the only check on that was a signature match. And if there's no problem with the signatures, why does every single county and state refuse to allow anyone to independently confirm the signatures?
It's fascinating, and it's there's no good answer that I've heard yet. Now I just want to bring this one up. Nate the lawyer says they could have sued earlier. This is in reference to Pennsylvania Act 77. They could have sued earlier under imminent enforcement. Circumstances are that threatened enforcement sufficiently imminent, early standing.
To be clear, I don't agree with any of these standing latches or mootness doctrines. But having gone through it repeatedly in election law cases, well, Nate is right. Courts go the opposite way unless you scream bloody murder. So I have brought suits early, and what I do is I find the time the courts had previously denied standing, and or said something was latches or moot, and I file early, and I say, hey, look, you said before you have to file early. And these courts still, if it was a different lawyer that didn't know how to advocate for that, you frequently get dismissed. It happened repeatedly to the Trump campaign throughout this election season. They filed, I think, 3 different federal lawsuits, at least 2 that I know of, but I think 3 were just about Pennsylvania, and they got no relief from any of the 3. And they said, look, this is the imminent enforcement problem that's happening. Court still denied it in part on grounds of no standing. So the reason is this: unless you're a favored group, they just don't get involved. Third parties don't get involved. Independents don't get involved. If you're a third party, you're independent, or you're someone they don't like, they create all kinds of absurd rules for why you can't get access to the court system and why you cannot get remedy. Standing has always been a bogus doctrine. They invented it in 1922. It's not a real doctrine. It's not rooted in the Constitution. The word isn't even in there. It says cases or controversies. And I think for most ordinary people, they're shocked by the idea that if my vote is diluted by voter fraud, I have no legal remedy because the courts come up with these. What courts don't realize is they've historically got away with this because they were picking on little guys. They're picking on the naders. They were picking on the Greens. They're picking on the libertarians. They're picking on small independents, like a little independent I represented up in Virginia. He was taking his time off just to try to make a little difference by getting on the ballot. And they made it hard as possible for him to do so. And Justice Roberts, by the way, was happy to enforce those rules. So it's interesting which rules he was strictly enforcing. He didn't enforce any of the rules that restricted mail-in balloting, but by golly, he made sure that those little third parties and independents couldn't get initiatives or referendum on the ballot. Federal court here in Nevada was real happy to enforce those signature rules in the middle of a pandemic, simply to keep a referendum or a recall petition on the governor from being instated. So I agree with Nate, that's what the rules should be, but the reality in federal and state court, and when it comes to election disputes in particular, is they got 20 different Pontius Pilate excuses in their little book. And they just bring them out whenever they want to not deal with the substance of an issue and try to make you look bad. Why didn't you do this? Why didn't you do that?
That's what drives me nuts is they say it's when they want to get to the conclusion, they can say what you didn't do, blame you for what you didn't do, and then blame you for what you did do. Had they filed then and filed now, you're filing too many suits. It's the way of getting to the conclusion it's the way of arguing from the conclusion as opposed to getting to it. Now, I missed 3 super chats, and I don't know how they blew by, but I want to give them the required shout out. Craig Lino 504 says, I'm hoping Biden's threats to pack the court will give the Republican justices a motive to protect their power and give Trump a fair hearing. What are your thoughts?
SCOTUS is critical. The 3 real bodies where Trump has a potential edge was never going to be in the lower courts at the state court level. Maybe the state Supreme Court could get occasionally with some of these states, not Pennsylvania, but you would have thought Michigan, but even they dodged the issue. Maybe an outside shot in Wisconsin, maybe a shot in Georgia, maybe a shot in Arizona. Otherwise, it was with state legislatures who are remember, many of these state legislatures passed some of these crazy election rules in the first place. So they don't want to really be exposed. They don't want to have to deal with it, but they're just starting to get the message that the Trump voter base is not going to accept them playing docile and being weak and going along with these illicit actions that they see in the election process. So they're starting to wake up a little bit, but the big one is Congress and the Supreme Court. And he needs some cover from the Supreme Court. And as he himself said this morning, he's like, hey, that's a crapshoot. He's recognizing that even though he put 3 of the justices on there, that he doesn't have because he's seen crazy rulings from them before the election, not getting involved. They could have cleaned up a lot of this. And Barrett did her version of Pontius Pilate. Oh, golly gee, it's so complicated. I can't figure that out in 24 hours, even though I'm supposed to be the smartest justice ever appointed. I'm sorry, I don't credit that. So now there's a shot. Barrett might step up to the plate. She stepped up to the plate in the church decision, but that's not a big surprise. Church and gun issues she's going to be good on, but it's a crapshoot is the short answer. Will the Supreme Court, will the Senate, will the state legislatures step up that are already Republican, step up for Trump, or will they abandon and abscond like they want it, like the cowards many of them naturally are? That's the open question.
All right. And we got from Corliss Drinkard says, what should we do? What should we who live in uncontested states do to help push the election into the House?
Contact your U.S. Senator or any other U.S. Senator, Rick Scott, Rand Paul, the people, Ted Cruz, any of them who actually, Josh Hawley, if they have real presidential ambitions, they're going to need to step up because Trump is signaling he's not going to go gently into the good night. He's come to the complete once. I won't get into certain conversations, but let's put it this way. If they had allowed the signature match audits to occur, Trump would have been willing to step back and say, okay, all right, they stole it legally. They got one over on me. God bless. Well, let's see what happens next time. But once they didn't, that is when he came to. That's why he said what he said this morning. He waited several weeks. He could have been saying this for weeks. He didn't. He waited to see what happened. And when he saw nobody was willing to let him take a single look at the signatures, and all the courts were coming up with bogus excuses for why they couldn't handle the case and taking cheap potshots at him that are often baseless in law or fact, then that's when he was like, okay, you stole it from me. Now you think you're going to get away with it. And I'm not going to go gently into that good night. I'm going to document and detail it. And that means all the Republican state legislators, Brian Kemp may have just ended his political career by not stepping up to the plate. His only future, the governor of Georgia, is if he steps up to the plate between now and whenever the elector certification takes place. And by the way, they all can. Just because they've certified the election isn't the same as certifying the electors. That's a separate step. And certifying the electors is the only consequential one. And to give an example, like the lack of historical context because of the gaslighting by media and law Twitter. And just one aside, I really don't take well to all these power arguments. When I get these people say, oh, look at how many times the courts have shot these arguments down. I'm like, you could have told the NAACP the same thing in 1949. You could have said, you've spent 60 years losing. Your civil rights arguments must not be any good. That's an argument from power, not an argument from principle. And it's not really an argument I respect. It may be a practical reality we have to deal with, but that doesn't make it a principled or intellectual argument or moral argument of any merit. Just saying, look at who has the power. Whoop-de-doo. The Nazis had the power. Does that mean anything they did was right? Putting that aside, the core of it is Trump has limited allies, but these allies are going to need to step up to the plate because he's now making it clear. So everybody who's in a state where it's not contested, they still can become active and learn how to reform their elections because problems will come about if we don't have real election law reform everywhere. But the other place they can be active, I'll give an example. On our locals board, Viva barneslaw.locals.com, created in part to create a community where people could interact. Well, one of the guys who's not, I believe, is in an uncontested state said, I'll create a website where we can crowdsource evidence. And he called here'stheevidence.com. And he just started crowdsourcing, gathering where he could and letting other people upload affidavits, upload declarations, upload sworn testimony to be able to make it. And now Sidney Powell and Trump's lawyers and other people are using that site to help gather evidence and information. So there's lots of ways to help.
It's amazing. Chewy, incidentally, is another super chat I missed. Respectfully, Barnes keeps talking about Trump's momentum for 2024. System is proven broken with recent decisions. What momentum when Trump is locked up and 2024 rigged again with no change or penalty, with no charge or penalty? Change. Here, someone else had asked in another super chat, there's talk of Trump getting indicted when he leaves office. I mean, what do you say to quell those concerns, which I think are not unreasonable concerns of people now?
There's no question the system may come after him, may try to double down, and there's sort of a bartering negotiation kind of going on effectively. But as Scott Adams pointed out, that's not a persuasive argument to someone like Trump. Someone like Trump, he doubles down when he hears people talking about indicting him after the election. As Scott Adams put it, a rational response of someone would be to increase their efforts to gain and keep power when you're saying, as soon as you're out of power, I would like to indict you. So, it's not a smart strategy of Democrats to be pushing that, though I think they're doing so in the guise of maybe we won't if you play nice and go away. No question, it's a risk. And I understand people are like, if we don't win now, it's all over. I've just been through too many of these battles and studied enough of history. That's just never true. This feels like Act 2, not Act 3. So the idea that I understand where people can get invested to the point where, like, if we don't win this, it's done. It's just history says otherwise. If Andrew Jackson had won in 1824, he probably gets it stolen from him in 1828, and Jacksonian America and Jacksonian democracy never exists probably. But instead, because he had it stolen from him in 1824, he built a real army, political army by 1828 that would last at least 40 years or up to 1860. And in core form, the same group of people would keep voting for that party for the next almost 200 years. So history says that just because you suffer a setback in battle, it is almost never the end of the war. And I don't think it will be here. I think the way Trump is handling it is correct, fighting it through the legal channels. If he's unsuccessful in the legal channels, then he'll seek political remedy down the road. But he's relying upon untrustworthy allies, unreliable allies, and that's his hurdle. And that's a hurdle, frankly, that can only be overcome by building a real political machine 4 years from now. It's not something that can be overcome in 4 weeks.
All right. And the Royal Canadian Moose says, I showed some leftists the website Here Is the Evidence and got mocked for it because it said there were sources from YouTube and Twitter comments. Hey, crowdsourcing information means you're going to get good stuff and less good stuff.
Oh, sure.
It's an amazing thing.
And it's a wide range of sources of information. Some is affidavits, some is declarations, some is just the way people, but like, for example, I don't get people criticizing, let's say, well, this statement's on Twitter. It's still a statement, right? So or they're citing a study. They're doing a study. How is it different if I put a fancy book cover on it and call it a study? Suddenly, magically, it reaches new evidentiary value.
Put it in the New York Times. It reaches new evidentiary value to some.
Well, it does. Well, that's why I like to cite the New York Times. The New York Times said election experts said absentee balloting is rife for fraud, and the next time we have massive increases in absentee balloting, we'll have a massive increase in fraud. That's what they said in 2012.
And incidentally, now Snake Plissken and a bunch of others have been asking, what is the status on the signature checking in Georgia? Are they checking them or not? Are they cross?
Not yet. They're coming up with every excuse why they can't do it.
What could possibly be the excuses? Like, what's the first one? Not enough time?
I don't even know what the new one is. When I was there, they promised me to do it, and then they said they just weren't going to do it. So they promised for a week they would do it. Then when they thought they had cover because of how they interpreted Sidney Powell's allegations, they withdrew those provisions, which told me that I think what they did is they used that time to take a look at them and found problems. And that they know there are problems, and they're like, well, we can't really do it now. I mean, again, this is easy. I hear people saying, oh, don't worry, the signature matches were done. My analogy is this. It would be like we clearly have statistical anomalies. So it'd be like if you had a company whose books had not been audited, and you're seeing financial irregularities, and we're seeing a lot of voting irregularities that took place. No real doubt about that. There's doubt about how to interpret it. There's doubt about whether it means it's fraud. But there's no doubt that we have systemic irregularities. Every single bellwether county voted, 15 bellwether counties voted for Trump that have been predictive for the last 50 years. And suddenly they're not predictive at all in this election. I mean, Florida and Ohio vote more for Trump, and yet somehow Trump lost ground in the other states that they've always been a barometer of. So there's indubitable. Atlanta has a ridiculous suburban increase in Biden vote, more so than any suburban area in the entire country. These are irregularities. So we have some people with books that have irregularities, and we're saying, can we please look at the books? And they're like, no, don't worry, trust us. And then when we find a way to get access to the books go missing. Like what's happened in Pennsylvania. Apparently they're doing the same thing in Georgia. They're sort of fixing the computers. There's people that claim the bad ballot envelopes now are missing in some places. Whatever it is, they're acting. You look at every act you would identify as indicia of fraud in terms of systemic irregularity, in terms of sort of accounting anomalies, in terms of not allowing audits to occur, and then evidence going missing, not allowing monitoring to take place. All of them are present here in all of the key contested states. This is highly irregular and highly unusual. What
is the website again, Robert? People are asking for it.
Here's the evidence.com.
Okay, here's the evidence.
You can find it on it should be on our locals board. I'll put it up. I'll pin it on our locals board so that people can find it, which is vivabarneslaw.locals.com.
Okay, now this is great. I think that covers a lot of the things. The one I think we should get into, I know a lot of people want you to get into it, and they want to know what you think now that the lawsuits have been filed. Let's get into the Sidney Powell lawsuits. She filed now in Georgia and Michigan, correct?
I believe so, yes.
Now, and then it's going to bring me into this Raffensperger settlement agreement that I messaged you over before, but I think we've already seen it before in Georgia. Which, if people don't know about it, it's going to really blow your minds in terms of Raffensperger now having his own skin in the game and his own tushy potentially on the line for what he did, and now it's coming to light. Overall, what do you think of Sidney Powell's lawsuit? Is it what was promised? Do you take back anything you said last week? Do you want to clarify anything you said last week?
So, I mean, I think there's different components to it. She took all of the different information that was out there and aggregated it together. So she included Matt Brainerd's information. She included statistical anomalous information, included affidavits that Georgia Republicans were gathering on a local basis, that the Michigan lawsuit guy had put together, aggregated all of that together, aggregated prior complaints about Dominion, and included all of that, added one or two components of her own. And I think did a good job of, in terms of, in summary fashion, of including all the potential allegations and issues. The potential weaknesses with the claim are, one, is filing it in federal court, and I'm not sure why she did that. The reason is at this stage, once it's post certification, the place to file is in state court, because usually you have election contest remedies, and she actually added an election contest to the claim, but she filed it in federal court. The limitation there is, in Georgia law, election contests really appear to you can only legally file them in state court. They have these expedited remedies. And if you don't file it in time in state court, you may be out of time and never be able to contest the election. And so by filing in federal court may create a problem for her, in which she never gets a chance to have the election contest adjudicated. The second is she has the same issue of standing that Lynn Wood had. And Lynn Wood is part of the Sidney Powell suit, too. He's one of the lawyers, not one of the parties. And now she has the electors. She has many of Trump's electors from Georgia as part of the suit. And theoretically, they're the candidate, and they can step in the shoes of the candidate, because technically they are kind of the candidate, legally, technically. And that may get them past certain standing issues. They drew a decent judge who initially granted an injunction and then withdrew the request within an hour because of standing issues. So, and because of who they sued. They didn't sue all the counties.
Someone messaged me that, and they say, how does that possibly happen? The judge issues a judgment. Was it on appeal? Was it on a motion for reconsideration? Or did the judge just do it of his or her own volition?
So Sidney Powell requested a preliminary injunction on grounds that some counties were deleting computer file records pertinent to their claims. So, but the Secretary of State came in and made 2 points. One, that they don't have standing to sue based on what the other federal court judge had said in Lynn Wood's case. And second, that they had not sued the counties, and that was all in the custody of the counties, and they couldn't do anything about it. By the way, it frankly, either way, why is the Secretary of State coming up with excuses for the county to destroy evidence and information? This guy is such a fraud, such a phony, such a fake. His representatives lied to me for 2 weeks. And by the way, his lawyers were supposed to be Trump's campaign's lawyers. That's why Trump's campaign's lawyers were lying to Trump's campaign right after the election. So that's the kind of scams we're talking about here. So, that's how the judge reversed it. The problem is that those are two big hurdles. If you want to make sure you have complete control over the election process in Georgia, you have to sue all of the counties. In an election contest, you can just sue the Secretary of State, because that's the certifying official, and the state court judge will grant you immediate discovery as to everything else. You don't have to sue all the counties. But if you want to enjoin the counties in a federal suit, you got to add. Now, that's a drag, because that's 159 counties. And if you're sued by election board member, that's whatever, it's serving 800, 900 people. So, that's what, $400 a pop sometimes for service of process. So that can get expensive. But I think some of this is reflective that there's still no election lawyer involved. So there's almost no election lawyer involved in any of Trump's cases. So it's a major hurdle. And it's how they get behind the 8 ball in the Pennsylvania. They make it easy for the Pennsylvania federal court to take pot shots at him because of how they file the case. They make it easy in other places because they don't know quite. I mean, for example, the Trump campaign, I don't believe, did file a timely Pennsylvania contest. Luckily, I believe some voters did, but I don't think the Trump campaign did, because my guess is Rudy doesn't even know about that. So what Rudy is good at is the PR side. He's good at the hearings, those legislative hearings, talking on TV. That should have been his role, not running the actual litigation side. And Sidney Powell, God bless, you really needed to incorporate an election contest or election lawyer into the case to say, here's, if you're going to go this procedurally, you can file your federal civil rights actions in state court, and you file your election contest where you have broad remedies, but you have to be ready to rock. You got to be, like I said, ready to go in 5 days typically in Georgia. So those are the weaknesses to the case. I think the public reaction, and law Twitter was always going to be hypercritical, but in terms of evidence, I don't think she produced any new evidence that necessarily reached Kraken standards. Now sometimes people do that. They oversell to get attention, thinking that's what's necessary to get attention in the first place. So that may have been her strategic objective. But I didn't see new evidence that suggested algorithmic fraud is at the source of this election. Doesn't mean that such evidence can't exist. I just didn't see it in the complaint.
And see, that was my bottom line takeaway as well, is in the absence of those press conferences and the public statements prior to releasing the lawsuit would read pretty well. I mean, I don't care about the typos. I think a lot of people are making hay of the typos. Some of them are just formatting or condensing issues when you turn a document into a digital document. But I would say in the absence of those, in the absence of the hype, the lawsuit is decent on the constitutional questions. It's a little weak on the evidentiary issues relating to Dominion and Venezuela and everything. And so if it were just the lawsuits, it would be one thing. It was just specifically, in light of those comments, the affirmations that I took to be very convincing that there's determinate evidence, not old affidavits and not expert evidence. And I've looked through it. I haven't done a video on it. It's too much almost. And, a lot of other people are covering it. A lot of those affidavits from the experts, they're opinion affidavits. They're not firsthand, I coded this and this is how it's coded. It's not firsthand, this is what happened at Dominion offices. They are, in my opinion, it's likely that it's fraught for, I could hack in 7 minutes with a screwdriver, not I did hack in 7 minutes with a screwdriver. So that's where I think it's problematic in light of the previous statements that were being made. It's sort of a letdown for a lot of the people who had this faith that there was going to be I don't know what the analogy is, but like this golden hammer that was going to smash everything open. It didn't happen. Some of the good arguments, and if anybody doesn't know this, Georgia specifically, one of the strongest arguments, it was covered in another lawsuit, was this confidential settlement agreement that Raffensperger entered into pre-election with Democrat entities. I don't know what they were. They're political parties or they're political entities. A settlement agreement that I think was confidential that basically dictated how absentee ballots were going to be treated and how signature matches were going to be treated, and created such an onerous, unreasonable cross-check for signatures. They basically made cross-checking signatures impossible in Georgia. And it's something like, somebody's going to review it. If one person thinks that the signatures don't match, they're going to get two other people. They're going to convene a majority of the two of them to determine if it's sufficiently accurate to match. And I guarantee that never happened in any of them, which probably explains how there was no throwing out of any absentee ballots, the vast majority of which we knew were going to come in for Biden. So that's the strongest thing in that lawsuit, in my humble opinion. If people don't know about it, just look up the Raffensperger secret settlement agreement. I mean, Robert, how does that happen? How does a settlement agreement affect protocol for an election?
Well, there's two different issues there. By the way, the Trump judge also dismissed Lynn Wood's claim on that on laches grounds. Isn't that something? Why didn't you just rush to sue even when you didn't know about the problem? I mean, this is the kind of another Trump appointee, another Federalist Society guy, a guy I knew from his tax division days, a Rosenstein type. And so not a surprise, Rosenstein was also the tax division, also Federalist Society member. I'm going to keep lecturing on that for years because we need to break up their monopoly, folks. But so they did this all across the country. Georgia was not the only one. Beginning in spring, Mark Elias and aligned, affiliated, associated Democratic front groups waged a legal war on pretty much all the states, even states they didn't think they were going to win, like Tennessee, saying to not enforce signature match checks and to allow notice and cure opportunities. And so they were filing suits in some cases. They were threatening suits in other cases. They got the Michigan Secretary of State to issue a preposterous signature match set of standards. And by the way, we have standards out there. We have standards from Oregon. We have standards from Colorado. There's video training they do by the Georgia Bureau of Investigation, according to the Secretary of State. Instead, they scrapped all those standards. And like they have the Michigan Secretary of State to say that if your signature looks exactly like it normally does, then that's probably a match. But if it looks completely radically different, in other words, you went from a cursive signature to a block print, first grader signature, they said maybe that's still a match. They said if you went from a long cursive signature to one line, maybe that's still a match. Those are just questionable. That's how absurd they intimidated every election official in the country into not enforcing signature match standards. That's how they were able to increase the vote totals everywhere, because they wanted no anomalies. They didn't want Tennessee showing totally different absentee ballot rejection rates than Georgia. So that's why they threatened everybody. They did it mostly behind the scenes. Some of the cases actually became public. Now, this is where Trump's campaign legal team was asleep at the wheel and, in my view, engaged in massive legal malpractice. They should have been challenging this. They should have been contesting this, and most of them were not. They were, in some cases, they weren't meaningfully aware. Now, I think that settlement was not fully a secret settlement. That suit was public. They just weren't monitoring and tracking the suits the way Mark Elias does for the Democratic Party. And they don't have a coordinated approach. Many of the people in the legal world don't like Trump, even if they're nominally Republican. The few that do are often conflicted because they represent the Secretary of State. I mean, that was the problem. The people representing the Secretary of State are purportedly Trump's campaign people. So do you think they're going to expose their other client, their paying client, Secretary of State, their future paying client? I mean, they had a conflict in such a way they couldn't be involved. But they were pitching people, don't worry, because we have these relationships, it will help you. They haven't helped any. All those folks Trump has got legal malpractice claims against a lot of people if he ever wants to bring them.
This was something I was thinking, and now in hindsight, appreciating when they were talking about amassing an army of lawyers for the Democrats were in the months leading up to the election. Now I'm really appreciating what it meant is that they filed these lawsuits. The settlement agreement, I was just checking to see if the word confidential was in it. Doesn't seem to be in it, so it probably wasn't confidential, but I suspect it wasn't well known or widely known that they basically, in a settlement, to which Raffensperger was, a party, said, we're going to create such an onerous cross-checking of signatures that it's basically not going to happen in real time or if ever. And now Raffensperger, who has his name on that settlement, is somehow going to has a vested interest in protecting the outcome, because otherwise it looks like he contributed to the outcome, notwithstanding his political affiliation.
And that isn't all he did. He partnered with the ACLU to help, quote, monitor the signature match process. He partnered with various Stacey Abrams groups to help send out massive ballots in the primary to increase ballot primary participation. He allowed for drop boxes to be used throughout the state, so you'd have no meaningful chain of custody of ballots. So mistake after, when issues rose about whether Dominion was pre-printing ballots that were not being spoiled that could be replace future ballots, he took no corrective action. And now he has refused to do the audit that he promised the whole state he would do. Go back to look at CBS, look at his name, and look up, recanvass, audit, and recount. He said he was going to do all three at the same time. He lied to the whole state. So the bottom line is he is neck deep with a lot of these people. The lieutenant governor's neck deep with them. The governor's neck deep with them. The Purdue political machine has not been doing anything to help Trump, even though one of them has a cabinet position and the other one is running for Senate in the runoff. So it's Georgia's Republican Party, institutional party, is a useless institutional party. Now, the party people are good. It's the people who hold elected office are bad. That's the problem.
Okay, here we got Craig Lino says, is there time for Sidney to file injunctions against each county before the evidence on the machines are wiped? Can there be an adverse presumption of fraud based on spoliation of evidence? So one of the conclusions that Sidney is seeking in her lawsuits, which we'll see if any judge is going to grant it, is, what do we call it, seizing or preserving the voting machines or the information on them. Going to the question, is there time? What are the chances of the judges grant that?
I mean, here's the big problem. It's highly likely all of her federal cases will be dismissed for lack of standing. So it's going to be very hard to overcome that. That's where they've been going. My view was it was worth trying the federal courts before you could even get to an election contest stage, pre-certification. But one, it was, you have state remedies that are better and broader. Number two, the federal courts have proven now they're useless. So you can always get to the U.S. Supreme Court through the state court system. You don't need the federal court system to get there. So once it was becoming clear that federal district courts were going to do Pontius Pilate and federal appellate courts were going to be arrogant, condescending versions of Pontius Pilate, it was time to skip those. Just go to state court, start attacking in state court. Now you have, because you have a lot of state courts where the local court might be fair, like you got in Pennsylvania. You got a very fair ruling. You got some Supreme Courts in several of these states where you've got some smart judges on there that might take meaningful remedy, that are not as sort of Pontius Pilate corrupted the way the federal courts have institutionally become over time because of too many of these Federalist Society types. A lot of these state court judges are not Federalist Society types. Notice the difference.
Oh, and I promised someone earlier you would remind everyone what your issue is with the Federalist Society. Some people who are first-time watchers may not know why you take issue with them.
The Federalist Society's developed a monopoly on appointments to power, particularly in the federal system, on the right, so that almost nobody gets approved for a position of power unless you're in the Federalist Society. But the Federalist Society promotes political bootlickers and establishment cowards. And so the only people they'll come to fight for are Bushes. The only people they'll come to fight for are establishment types. They will often cover up for the system. That's, how is Christopher Wray, head of the FBI, has done nothing whatsoever to deal with the problems from Spygate, to deal with the problems from Ukrainegate, to deal with the problems of all these illicit ballot activities likely having taken place right under his nose while he was promising to monitor it. He was more concerned with Russian hacking. He was more concerned, which has always been a bugaboo. He was more concerned with alt-right rising from somewhere and being this huge group, and there's maybe 200 of them in the whole country. So he was busy propagating and pushing liberal talking points because the Federalist Society has a bunch of traitors in it. So there are people that you should never have one group monopolize federal appointments to legal positions of power. That's always a bad idea. Number two, this particular group has disproportionately promoted terrible people. About half of their choice, the people they recommend, will be awful and will not be loyal, at least not to any kind of populist or true constitutional kind of independent liberties-oriented view of the world. They're establishment corporate types. Now, if you want to protect, if you're the Koch brothers, you love the Federalist Society because they'll probably even come to protect big tech when the time comes. They love to gut antitrust law when the time comes. Just look at what most of their work is and look at the fingerprints of who is on there. And no better example than this election. 4 different Federalist Society judges, 3 of them Trump appointees, all of them refusing to take any remedial action in the election contest and usually taking pot shots at Trump in the process. What does that tell you about who these people are?
Okay, now let me think. What do we do here? There was one thing in the Georgia. So we had the Georgia settlement, the Georgia lawsuit, the conclusions, likelihood of where it's going to go. Michigan, it's the same basic suit coming out of Michigan. There's more affidavit evidence that's accessible online.
Dismissal is likely there too, though the supplemental jurisdiction claim may hold. But if it doesn't, then the same problem is present. Now, the Michigan Supreme Court judges in concurrence made good points about the constitutional right to audit in Michigan. And so more people should that are in Michigan try to follow up on that. There is the suit that was part of that I believe is still going to be going on. It's just the emergency injunctive relief was denied. But that meaningful audit procedure should be enforced and interpreted. And so hopefully that at least election reform comes out of it. But I believe an election contest will be filed by the Trump campaign in Michigan. I believe an election contest of a form of it has been filed with the original petition with the Wisconsin Supreme Court. That's going to move forward. Trump campaign is going to be filing challenges to a lot of these ballots where they let people vote that did not meet the legal standard in Wisconsin. You're going to see a common pattern. A bunch of people voted who did not have a lawful right to vote, either by the manner they voted or because they weren't even lawfully registered in the first place, or they were out of state or something else. And that's going to aggregate into a narrative in all of these jurisdictions, all of which could go up to the U.S. Supreme Court. And ultimately, it's going to be do the state legislature, to give people a history example, in 1876, there's nothing that prohibits the state legislators from certifying to Congress their own electors because they have doubts about who won the election or they believe Trump actually did win an honest election. There's nothing that prohibits that. 1876, that's what happened. And what you had was back then, the election officials who certified the ballot were mostly controlled by the Republicans, the canvassers in these various states. And so they certified for the Republican candidate. The Democratic state legislatures got together and they said, nah, we're going to have our own electors and we're going to send them up. And so what happened is Congress got 2 sets of electors from 4 different states. So nothing prohibits the state legislatures from doing this all on their own accord. There's federal law interpretation that says you can rely on the governor rather than the state legislature, but that raises constitutional questions because the electors clause says, no, it's the state legislatures that choose. And the U.S. Supreme Court, both in 1892 and again in 2000, said that the state legislatures can use their power or retract their power whenever they want, that it's plenary and it's not subject to judicial review.
Yeah,
all of them can do that. In addition, the House and the Senate can join and object. So these remedies and the Supreme Court can get involved. The three places where Trump should have allies on paper can all take remedial action. The question is, and they have beyond the question earlier about December 8th, December 14th. The Electoral College meets on December 14th, but there actually isn't certification of the electors until January 6th. So really, that's the drop dead date. It's what Congress certifies. And in my view, the real drop dead date is not till January 20th. It's not till Inauguration Day. To give an example, in 1876, back when Inauguration Day was in March, they didn't decide the issue until 48 hours before Inauguration Day.
Yeah, but some people are pointing out that, it's a different information age now. You have the media having set up an expectation and 75 million people dancing in the streets. That'll change the dynamic much more in terms of what people might be, politicians might be willing to deal with in terms of blowback if they actually certify the electors in a way that the state did not turn.
But what's their blowback if they certify an election that their own voters think is fraudulent?
That's I can't answer that question, but a lot of people are asking it in the chat. What do we got here? We got Cleopatra's in the house. Hey, Viva and Barnes, I'm very late and we'll have to catch up tomorrow. No matter what happens, I won't give up hope until it's over. Cleopatra, good to see you. And thank you very much. Now, it sort of brings us to this question. Tanja Pisler says, Barnes, if you were President Trump, how would you play it? What's the best third act?
Honestly, the best third act is to set up that the election was stolen, allow the institution, push it through every institutional remedy you have, let them fail you. And if they do, simply use that as ammunition to build a real independent coalition of your own allied individuals and officials, and use the next 4 years to do what Andrew Jackson did between 1824 and 1828, and build a movement that is far more impactful. Build a movement that isn't infiltrated easily by the QAnon types that take things in a direction that's different than I think is productive. Build or the corrupt insiders that are undermining you at every turn. That the only thing they have for you when your back is turned is a knife. That you have the people that have your back, not the people that want to put a knife in your back. Build an independent media army. I mean, for example, almost all the tools of modern campaigning, Andrew Jackson invented for 1828. Almost all the things that we associate with modern campaigns in terms of paraphernalia, mailers, you name it, Andrew Jackson created out of thin air. So he created it because he knew he had to. He had to find new means to reach people, new means to communicate to people, new means to organize people, and build a real network of deep organizational ties. And that's how it happened. That's also how 1776 happened. That's Kevin Phelps' book, 1775, The Year of Revolution, about how 1775 is what really created the revolution, even more so than 1776. It laid the groundwork for it. Unruly Americans, about how the Bill of Rights was amended by the public reacting and organizing. So often it's the case that you have to lose something to win something big. So that's where people think I'm not giving up or anything else. There's still a chance, and on law and on facts, he should prevail. But I'm saying be prepared that doesn't happen, but don't use the defeat, if defeat is what occurs, as a permanent setback. Use it as an opportunity. Do what Trump says. But I can personally assure people Trump's mindset is very much a positive one. It is not a negative one at all. All these articles you're reading about, he's mad and he's angry and he's more. None of that is true. Just the opposite. Shockingly optimistic, frankly. Because his view is, I'm going to march forward. Maybe the system does it right. Maybe it doesn't. If it doesn't, I'm going to march forward in 4 years. And we're going to build something real strong that lasts, that's independent. And I'm going to have fun doing it. You add Trump TV, you add a real Trump organization, you build independent, you support and prop up independent internet social media sites, then you can help build the machine that can outlast and that be much, much stronger in 4 years than frankly it would be if he wins power now.
Okay, amazing. Now, this is also a comment I've been seeing a lot of, claims regarding a German server that was seized. And there were some other comments to that effect, but are you familiar with this discussion about servers that were seized in Germany that might relate to this election?
Highly unlikely for it to be true. And my problem with making those claims is you really better have some evidentiary background. Because take, for example, Powell files suit, initially gets relief from the federal court. An hour later, he reverses himself. That's a sign of a federal court that was probably leaning your direction. And then the opposite side points out big flaws in the case, and he all of a sudden pulls back. And what may happen is the evidentiary weak links will be highlighted, while the evidentiary strengths will be buried. And if you lose the confidence of a judge when you're asking them to do something extraordinary for a judge, it shouldn't be extraordinary, but it is in their mindset. These are cautious actors by nature. These are not the most, path blazing people in the world. That's the exception, not the norm. And so you can lose them. This is why, every lawyer will say it's not what you know, it's not what you think you know, it's what you can prove. So focus on the most provable claims, and you only take a Hail Mary long shot with something you may not be able to prove when it's your only option, when it's your only alternative. If you're Johnny Cochran in the opening statement, you figure you need to get away with 6 other people that might have done the killing in OJ's case. That's when you do it, when you know that you're not going to be able to have evidence down the road. But if you have evidence, you focus on that evidence, not on things that are going to be tough to substantiate. And I've seen other people that are pro-Trump that are very data-connected individuals or connected into that world, and they're coming back saying these stories are not true. The server story never, I seriously doubt there'll ever be proof of it, put it that way. And it smacks of QAnon. So the other thing is, the people that are suspected of being behind QAnon, which is Ron Watkins and his father, Jim, he reads like a character out of a James Elroy book of a disinformation campaign. He was in the army and was early on involved in IT work, and then decides to move to the Philippines to help set up a Japanese porn site, and stays in the Philippines. It partially does pig farming and stuff like that. And there's real reason to believe a lot of people that have followed QAnon believe he's the source of it. I'm sorry, I don't trust that information. I don't trust it to be reliable. I definitely don't trust it to be provable, especially when it often has the hallmarks of disinformation and has the hallmarks of things that will discredit the legitimate evidentiary claims that she clearly has.
Yeah, and we'll see where it goes. I mean, look, she's filed. We'll see what the outcome is. The lawsuit itself, I've said it, it has some strong arguments. They're on the constitutional side, and the very weaker stuff is specifically that which was supposed to be the earth-shattering stuff, and that's where it stands with Sidney Powell suits. We'll see where it goes. I think we've covered these issues quite thoroughly. Some people are saying we have a lesser showing this week than last week because you have upset people, or we have upset people. I'm not even sure about that. I'm noticing some real bouncing around in the numbers that's not normal, like jumping up and down 2,000 live viewers, which is not normal. I've never seen it before. So I actually think it might be a smaller crowd this week just because it's Thanksgiving weekend, but the fluctuations I'm noticing in the live viewer numbers is not normal. But before we move on to the next subject, thank you, Barnes, for giving us hope. Since I know you are correct that Donald Trump will be fine no matter what, knowing him personally, I still wanted to hear what you just said. P.S. This is the first time in 5 years he has not come home to PB for Thanksgiving. It's and I know Robert, for everybody saying like, what's Robert doing? Get off your butt and do something. Robert's more involved than, he alludes to his involvement and says what he can. But Robert is not an armchair quarterback. So for anyone who's accusing him of that, or anyone who sees the accusations, just know that, and that's as much as we need to get into. Okay, so let's move off of the election stuff. It's 1 hour and 27 minutes in. Let's talk Flynn pardon. I guess it's sort of related, not related. Hold on. Is it the Flynn pardon? Okay, let's talk to Flynn pardon. Just get the basics out of the way. Why now? Why not wait until the day before the day before he's out of office if he doesn't get a second term? And strategery behind the pardon and your thoughts on it. I'll just briefly sum up the election stuff for folks out there with doubt. The state legislators can take action. They can send their own electors in on the grounds that they have doubts about the outcome of the election, or they believe Trump honestly won it. The same thing can the various Republican governors, like in Arizona and Georgia, can refuse to certify the actual electors on grounds there's doubt of the election outcome. Then the Congress can take action by objecting to it. They could determine that the law that's meant to limit their abilities doesn't really limit their abilities under the electors clause, and vote by state delegation and say that Trump is actually
actual winner if they so choose. The Supreme Court can get involved in any and all of these cases, even the cases they're saying are part of state law. Typically, Bush v. Gore, just read the whole decision. There's a lot in there about what their jurisdiction is. It ain't what law Twitter's claiming it is. So there's lots of remedies out there. There's lots of people that can take remedies. We're in a wait and see mode. My only view is, be prepared for those people not doing what they should do, but don't have the reaction of resignation, have the reaction of more activism, more organizing, more making a difference. So just on that. So on Flynn, in that context, I believe Trump knows who his adversaries are. I mean, he was very straightforward with Maria today. I won't pronunciate her last name because I'll butcher it. But on Fox, where he explained, look, he goes, I know it's a long shot here. We just need an honorable judge. It's really tough to get an honorable judge, which I think is fantastic. This is Trump reminding the judiciary at every level that he's going to expose their hypocrisy and fraud for what it is for the world to see. Just as he's exposed the deep state, just as he's exposed corruption within the FBI, within the State Department, within the CIA, within our institutional sources of power, within Congress, and now he's exposing it within the entire election arena, at even Republican secretaries of state and governors. So that's great to see. But I think the fact that he made this move was he figured I better make this move before I can't make it for any reason, which he means he's deeply distrustful. If you look at what he did right after they declared him not the winner, so the AP did, his first action was to change who was in charge of the Defense Department and to try to start to bring troops home now. So he properly attributes responsibility and accountability to what happened to those who have been fighting him for 4 years within the deepest parts of the deep state. And some people object to the term. It used to be a lefty term. It just means dual state in the apparatus of national security and law enforcement. And research dual state, that was a well-recognized political science principle for 140 years. This wasn't controversial until suddenly it was applied to people that were opposing Trump. But you don't have to be a QAnon believer to recognize that obvious reality. It's one of the problems with people who are critical of QAnon. They criticize things that are clearly true and actually give more credence to it than I think is sometimes warranted. But so I think that's part of why he did it. Part of cleaning up deep state apparatus. I think he recognizes now one of his great mistakes that he regrets is firing Flynn, that Flynn could have protected him from a lot of these actors over the last 4 years. And I think that was he was sort of a symbolic, signifying point of it. Some people think it's because he's going to bring in, oh, by the way, you're muted.
No, I think you can hear me now.
Oh, yeah.
Okay. No, well, I know that Cernovich was very critical of Trump for firing Flynn at the time. I think you were as well. Is it Laura Ingraham and Coulter. I think one of his diehard followers essentially turned on him. And I think the Flynn firing and not standing behind his friends turned them off. But no, so getting to the idea, a lot of people think now that Flynn is freed up, he can divulge information or he can participate in this process, or they're going to get some goods out of him. You're not as optimistic on that as other people?
He's been out of that for 4 years, really for about 6 or 7 years. So he's not really roped in. He was put under a lot of pressure to not have contact with any of his allies during the criminal case, because a lot of them were put under criminal investigation. People don't know that. And so, I mean, if Flynn the reason why they waited is what Flynn didn't realize this. He was identifying for them all the white hats within the entire national security apparatus by saying, here's what we're going to put on these positions. Here's who's going to be part of these committees. And they waited for him to do that before they took him out, because then they put every single one of those people, including people with like Flynn, impeccable records, no questions, etc., suddenly under meaningful criminal investigation. Several of them reached out to me for representation if the case had moved forward. So that's how I know those details. I won't go into further detail, but that gives you the scope of it. So I think Trump underappreciated what was happening, now appreciates what happened, and regrets what decision he made there. And of course, part of that was Pence. It was Pence's people who helped do it. Like, for example, in the election context, even left-wing legal scholars, they were saying this, by the way, back in after 2000. Like, one of my tricks for lawyers out there is find somewhere where the judge politics would have been on your side of the aisle in the past on that issue. Go back and find it, and you'll find interesting rulings and interesting case law, interesting legal work. Look at all the work legal historians and law review types and professors did between 2000 and 2004. You'll find all these interesting articles about how the Electoral College has independent power to do whatever they want, which is constitutionally true. That in fact the vice president, as the president of the Senate, when he takes in the electoral votes, he can decide which votes he certifies and which votes he doesn't. Does anyone doubt that if Kamala Harris had that power, she would exercise it accordingly? The lieutenant governor of Pennsylvania was just bragging how he would do it in the context of the state legislature being able to take action. But it was Pence's people that undermined Flynn, and it was again part of the problem. And so there was too many turncoats around Trump, and they did a very good job of getting rid of the people that could have been Trump's key allies. I mean, is it a coincidence that Roger Stone, Steve Bannon, General Flynn, and Julian Assange all get criminally prosecuted?
And 2 years ago, I would have thought I might have called this a theory, and as opposed to analyzing it, it's just empirical observation now. We've been talking about it. We've been seeing the politicization of the prosecutorial process. You see who the system runs into the ground, who they go after tooth and nail, while they're literally letting other people out of jail, or no recommendations of anything but, public consternation. It's undeniable, and it makes you feel like you've taken the red pill, or what some people call the black pill. But it's amazing. It's what I discovered following the Flynn case. I discovered the degree to which the entire system is politicized to the point of weaponized, and it's disheartening.
No doubt. Now, and Flynn does have some rights to sue. It's very tough to sue the prosecutors or other people involved. But I think he has legal malpractice for conflict of interest representation to at least get back his fees against his prior firm. I hope he does that. And he might have some of the same claims that Carter Page has. Good
segue. So for anybody who doesn't know, Carter Page is suing Strzok, a bunch of people from the FBI for, I don't know what to call it. You'd call it misconduct, except it's sort of fraudulent, or it's not, what's the word I'm looking for? Prosecutorial abuse. It's basically civil damages for having ruined his life through misrepresentations before the court. And we don't need to get into the bulk of it. I'm probably going to do a breakdown of it. It goes over all the allegations, the fraudulent FISA warrants, the fact that they've made admissions after the fact that they did in fact ruin his life, that they did in fact unlawfully obtain FISA warrants to go after him when there was no basis, and he's suing for damages. The cynic in me says chances of success are zero. This is telling your story, not winning. Am I being too cynical now?
No, he has a high chance because he has direct statutory claims. So the hardest part of his claims would have been any defamation claim and any Bivens claim. Bivens is the constitutional right to sue federal officers for a federal civil rights violation, but you don't get your attorney's fees, and there are certain limits on damages, and there are certain immunities you have to overcome. But in the FISA context, if you violate FISA, you have any person who's been victimized by any agent or any federal official violating FISA has a private cause of action directly against them for damages. And it's an underappreciated component of FISA. Normally, of course, you never find out that they violated FISA and screwed you. Carter Page is a very rare example of someone who has. So I think it's Leslie McAdoo Gordon is the counsel who drafted the suit. John Pierce is somehow involved, who I'm not a fan of, but we'll skip all that. She's a fantastic lawyer, drafted a great suit. First, identified the FISA violations. If you violate FISA law, there's a private right cause of action, including attorney's fees, including damages. On top of that, if you violate certain FOIA or Privacy Act laws, so if the FOIA and the Privacy Act sort of work together to allow you to get information on yourself that the government has, very underutilized set of records. People will be able to use state sunshine laws like the Georgia Open Records Act to get a lot of these files sooner at some point concerning the election, as an example. But it also has a limitation. The Privacy Act does not allow you to put out information about someone that you have within your possession unless it comes within the confines of the law. It also gives you a right to sue when they do so. So these are unique situations where immunity is not a defense, where truth is not a defense. It's just, did you disclose the information or not? Did you violate FISA laws or not? Did they injure Carter Page or not? There's no doubt they did. So he has a very, very vibrant, very strong claim that hopefully will set up a great precedent for the future to deter these kind of behaviors down the road.
And answering Truman H.W.'s question, I had the same question. First of all, do they have insurance? Do they have immunity? Are they protected if they're acting within the context of their employment? What are their defenses going to be?
Generally, the government will have to pay the price. So the government usually it's government's coffers. Sometimes it comes from individual coffers, but usually in these kind of cases, it comes from government coffers. Now, sometimes the government is insured in respect to it, but federal government usually they write the check.
All right. And then why does that remind me of something that we talked about in another lawsuit? The government taking up their defense. So does the government take up their defense? Do they have to mandate their own counsel, or does the government just cover a condemnation?
The government usually defends them.
Okay. I got booted from the stream twice. I have no doubt that's happening. And by the way, I'm not complaining. It's amazing, Robert. We have people enjoying a Sunday night listening to two lawyers talk about law. Never in a million years would I have thought about this. So so this is interesting. So you think he's got a decent case. Does it settle before it goes to discovery? Do they want to avoid discovery? Is there discovery? Are there any specific rules that we should know about for the lawsuit?
He has pretty broad discovery. So if he uses the case right, he's going to find out a lot of information, and he'll get past a motion to dismiss unless he gets a totally crazy judge that does something wacky. You can't rule that out in the District of Columbia, unfortunately. But he's got a great suit and great chance at real remedy. So I hope that happens.
Did they have a chance, or did they have an option to file in a different jurisdiction to get out of the craziness of DC, or no real option?
Probably not.
Okay. So that's very cool. Anyways, Carter Page, I'm gonna do a breakdown of the lawsuit because it's very interesting. I read it over the weekend, but again, en diagonale, as we say in French. Speaking of something I wanted to mention before I forget, the laches theory that we've been describing before. It's laches, Laches, and it's a French origin term. Lâche in French means lazy, or it means lazy or cowardice. And in this context, it's if you are lazy to avail yourself of your rights, you lose your rights. So we call it's laches in English, but I think technically it should be called lâche, but that would not. And
imagine that doctrine is being used by people who only sue when they are injured, when they had no reason to know that the certain law would injure them before the suit. When they know if they did file, they would have been dismissed before the suit. To call them lazy, the first time I heard it was when I was representing Ralph Nader when he was up against it and just filed when he had to. And I was like, this is absurd. So laches is what the court is doing. And you have to attack it like that. You have to say the one advantage of the Third Circuit's ruling is one issue I hope they do take up as part of that, or is the Supreme Court should clarify this nonsense. Quit doing this no standing before the election, laches after the election, mootness a month after the election. This is all nonsense. These are lazy excuses. Who's being laches are the judges. They're being lazy and acting out of cowardice.
Well, it's even now, and my father said this growing up, is that judges don't like making decisions. They like letting things run its course and then hopefully getting themselves out of having to make tough decisions. But this, I really get the feeling this can leave a different taste in people's mouths, where you get the feeling that the judges are trying to create a result as opposed to create a just result. And where they say, because we've seen it, dismissed because you have no standing, because you haven't suffered injury in fact, after the injury is sustained, dismissed because the damage is already done, there's nothing you can do about it, or dismissed because you waited too long. It's like, what the hell am I supposed to do? Just tell me what I'm supposed to say. But
it's like you're going to the court and you're saying this person keeps trying to break in the back door. Please have police do something. They're like, no, he hasn't broken in yet that we've caught him. So you have to wait until he commits the crime. Then he commits the crime. And they're like, it's too late. Already committed the crime. Sorry. That's what they're doing. And the ordinary person, when they hear these doctrines, they don't sell well to the public. They're like, standing what? Latches what? And then they hear how it's applied and they're like, that's absurd. It makes the courts look like the embarrassment they deserve to be. And so hopefully there'll be more criticism of the courts for these kind of rulings.
And your take on pardon? I brought up the super chat before. It was Sticks Hexenhammer says, pardon Assange, pardon Snowden, dump a bunch of info, let people know what's going on. You think it's going to happen?
I hope he does. I think he's waiting to see how everything fleshes out. Because again, he has governors that could take positive action. He has state legislators that could take positive action. He has Congress members that could take positive action. The House and the Senate could vote to contest an election or contest an issue and have a 2-hour hearing on it. or just scratch the existing law, recognize it's probably unconstitutional, and submit it to the House doing a state delegation. Supreme Court of States can take action. Supreme Courts of the United States can take action. State courts in election contests can take action. There's a lot of facts yet to be developed, a lot of hearings, public hearings and evidentiary hearings yet to occur. So all of that, I think he's waiting to see how all that plays out. He wasn't willing to wait to see how that played out before pardoning Flynn. I think he was concerned about I think he was making sure that they couldn't remove that remedy from him or have him, for whatever reason, incapacitated, because he started to realize these are the people the system has targeted almost as much as him. And so he's re-empowering those people who have been targeted by the system. So I hope he pardons Assange. I hope he pardons Snowden. These two people have done more to expose the system than anybody else. I think they were targeted. Assange in particular was targeted because of his perceived role as helping Trump in 2016, and his removal hurt Trump in 2020. And he's the greatest whistleblower and the publisher of whistleblower information in the history of America, and has done more damage to the deep states around the world than any single human being, probably in human history. So he deserves to be pardoned. The prosecution of him is nonsense. It was based on misleading information that was given to certain key actors within the Trump administration. So I hope he does, and I hope he declassifies as much as possible. Definitely declassify the Kennedy assassination files. Long overdue for that to happen. And declassify all this Russiagate stuff too.
Declassify UFOs on his way out.
Why not?
I had one thing. Like, how confident are you? I would imagine Flynn, for example, although he's been out of the intelligence community for 4 to 6 years, I have a feeling people like Flynn are never, ever fully out of the intelligence community, and they're just good at keeping secrets and good at disclosing secrets when they know that they have a secret that needs disclosure. Actually, never mind. That's just my own thoughts out loud. No need to comment, Robert. And this is a good segue. We got it. I probably missed it, but will this end up in the Supreme Court? And if so, please tell me it won't be just 5-4. That was a disgusting vote over religious freedom. Let's get into it. Cleopatra, thank you for the reminder. The Supreme Court decision coming out of New York. Again, I did a quick video on it yesterday with a kid sleeping in the car. Yesterday was a difficult day to be a parent. If anybody thinks, I only show the nice pictures and the nice, videos, but holy cow. So the kid was
had the great basketball shot today.
Oh God, that was it went in. I wasn't doing that again. So the Supreme Court decision is amazing, but it's sort of not super. It's not determinate. It really is only on suspending the execution of the executive order pending the appeal before the Court of Appeal, and if and when to the Supreme Court. And it was still split 5-4. And I might have to do an analysis of the Roberts versus Gorsuch part of it. But, in a nutshell, the Supreme Court 5-4 suspends execution of Cuomo's executive orders, which are moot now because they're not enforced, but they could be reimposed at any time, limiting the seating in synagogues and churches to either 10 or 25 people, depending on your zone, orange or red, regardless of the size of the institution, which can seat up to 1,000 people in some cases. Whereas just down the street, you can go to acupuncture and the limits are higher. You can go to Walmart, the limits are higher. How is it still split? I mean, I know on the technicality, but how does it need to get to the Supreme Court and still get split 5-4 for there to be equal treatment and not preferentially bad treatment to religious institutions?
It's definitely, educational. It's I think I have a new analogy, by the way, for Trump's election prospects. Instead of a Hail Mary, I'm going to say it's like a chance that Viva makes a blind shot from over his head. But that actually happened. So just a little reminder, folks.
True optimism. I only did it 3 times. That was the 3rd time I did it, and it went straight in. And I was dead.
3rd time's a charm. So it was a great ruling. I think Barrett will be good on issues of church and issues of gun rights and self-defense. I think there she'll be strong. The big question is how she'll be on the rest, how she'll be on the Jacobson legacy, how she'll be. What is nice is you're seeing enough of the attacks on Jacobson are starting to filter into the Supreme Court. Because, in fact, you're seeing other courts try to walk away from Jacobson. We're starting to recognize the problematic aspects, because I've always wanted to hammer for people. Jacobson is the foundation of the trilogy of infamy that led to the Buck and Korematsu decisions that allowed forced sterilizations and concentration camps ethnic-based concentration camps to happen in America. So if we don't want that to ever reoccur, we need to kill Jacobson and snuff it out. So it was good. So it is definitely disappointing that you have 4 Democratic justices who believe open, overt discrimination against religion is just fine, particularly as long as it's in the name of the white lab coat crowd. So that's the now the big difference between Democrats and Republicans on the bench is Democrats are almost strictly loyal to their fellow party members, causes or issues, whereas Republicans are all over the place. Some of them are because they're really institutionalist, some of them because they're really corporatist, some because they're weak and have cowardice. So for Roberts to write a part of the dissent was just an embarrassment. And I think Robert, people are trying to come up with excuses that the last living apologist for Roberts, that, hey, he's just trying to maintain the integrity of the court. Well, he's already killed that. He's killed that over the last year. Not getting involved in the election prior to the election led to a disaster that no matter what happens, half the country is going to think was stolen. So congratulations, Roberts. Now he probably won't get too many complaints in his, on his Manhattan summer parties, but or his Hampton summer parties, but that's the crowd he's chosen to sort of appeal to. So it is disappointing that Democrats, but this has been a function, this has been an ongoing building problem over the last 10 years, really the last 20, if you go back to law school, 25 even, because when I was in law school, this was becoming a problem. It was all ends justify the means. The law is just power. Use it to promote your side. Screw the adversary. Screw principle.
We've seen it in real time in McCloskey's. I'll say arguably Amy Cooper. I will say not arguably Sullivan. Say not arguably Elizabeth Warren. Not arguably Covington. The high-profile cases which have brought me to this world. We've seen it in real time. I've seen the Republican judges tend to be unpredictable in that they'll be subject based. Whereas I've just seen it when it becomes when it becomes remotely political or politicized, it's predictive. I would bet on it is how predictive it is. Yeah. So and then just to appreciate the dissent for everybody who's saying that it's not that they, the dissent did not say, okay, we tolerate a religious prosecution or persecution, I should say. They've said we don't really need to talk about it because the situation has changed. The restrictions aren't in place now because they've gone to a yellow, and so we don't need to deal with it. Which is more of the cowardice of just not getting clarity on something when it's in front of you. They say, literally, come back if and when it happens with an injunction and we'll deal with it then. Whereas by that time, it'll take a week, 2 weeks, a month to get in front of the Supreme Court or the required court. You'll have been screwed in that meantime anyhow. But that's it. Go wait. It doesn't apply now. Come back when the damage is there. Oh, the damage is there. Well, too bad you had to sustain that damage until. So in the meantime, now the underlying decision is in where now? The underlying decision is in the Court of Appeal.
It will go back to the district court in terms of fighting out the issue. But given what the Supreme Court ruled, that really that should end the case. Now, and what it does is effectively does, you know where the conclusion's going, and that means across the country. So these discriminatory practices targeting religious institutions should end, because anybody else who tries to continue them, like the governor of Nevada may, like the governor of California kind of still is, will lose now. So some of those earlier injunctions that were denied, those cases are still pending at the lower court level. So they're going to prevail now because they didn't have the ACB is Barrett is the most recent appointee who's going to be good on these issues. So it was a great win for non-discrimination against churches. It was a nice limitation, at least in part against lockdowns. It was a willingness to shoot down the Democratic governor Cuomo, who both he and the mayor have clearly targeted Orthodox Jews in particular for harassment in New York under the pretext of the pandemic.
Oh, there were videos of these guys looking through windows. It's nuts, and there's going to be arguments for why certain communities might not respect the rules as much as others, or might have secret weddings with thousands of people, or have the audacity in New Jersey of celebrating a bat mitzvah outside and inside. Arguments aside, it's in your face, and in New York, it's double in your face.
And it shows the overt hostility to the church that even someone like Cuomo comes up from the Italian Catholic tradition originally, his father did, is now willing to be openly and overtly anti-Catholic in the name of the pandemic. Because for people that don't know, they were applying different rules basically depending on whether you were going to a church or not. It was not a rule based on the number of congregants. It was not a rule based on the kind of physical space you were occupying. It was entirely discriminatory, targeting religious organizations.
And you know, and I made the video yesterday, which was poking fun at Mike Birbiglia, who says spins it, and I don't even know if he spun it or he just doesn't know. People think, oh, churches are out asking for special treatment. No, they're just looking. They were just asking not to be specifically treated with harsher treatments than Walmart, and then an acupuncturist or a garage or a plant that manufactures chemicals. I mean, it makes no sense. There's no other way to explain it other than it is targeted. And I don't know across the three big religions if it was targeted equally. I just know in this case, it was the church, the diocese, and the synagogue. And I did so actually before this super chat disappears, I have to say thank you very much, Andy Pearson. Why the hell hasn't Barr arrested anyone?
Yeah, I mean, it's embarrassing. It's embarrassing for Barr is fundamentally an institutionalist. I do think he wanted reform. He never got control of the people beneath him. Republican institutionalists have been unwilling to be ruthless in their implementation of power for Trump, the way they were willing to do so for Bush. And we've seen the net effect of that. And it's unfortunate. And so it's why deeper reform is needed, that regardless of the outcome of this election, deeper, wider, broader reform is needed. But that, people should not take a defeatist approach no matter what happens. One, there are a lot of remedies available to Trump. A lot of people have power to take that remedy, and maybe they will. But even if they won't, that's just a sign of the kind of institutional broad reform that's needed and necessary, and that historically has happened by ordinary everyday Americans to change the world. I mean, we've changed the world repeatedly. We were one of the first countries to abolish slavery, one of the first countries to expand suffrage, one of the first countries to institute real democracy. We ended racial discrimination in an extraordinary way. So the idea that we created a real labor movement that protected workers' rights in this country. So you watch a show like Warrior on Cinemax about 1894 Chinatown, and it's a reminder of how far we've come. So there's a lot to be hopeful for in the history of particularly the American experiment.
Yeah, and someone just posted, it's like, what a time to be alive. I'll see if I can bring up the comment again, because for good or for bad, we're living through some amazingly interesting times. So that is the Supreme Court, and it's going to set the precedent at the very least for other similar restrictions in other states that maybe Whitmer is going to take a hint, maybe Wolf is going to take a hint. But again, this specific case really only related to the differential or disparate treatment between church, synagogue, and secular institutions. The question is going to be, when it comes to just the overall lockdown orders, is there a decision like making its way up to the SCOTUS now on the broader questions here, or not yet?
No, not that I know of. So they had some opportunities to decide some of them, but passed on them in the summer. So I think that there's another challenge that's coming, and I think there's a lot of different lockdown lawsuits that I'm going to be looking at once we get through this election cycle and have some spare time. Then we'll be able to get to those cases, because I think there's some in Michigan and California, in New York, and other places that we're going to be looking at bringing to help shut down this possibility of this perilous precedent of Jacobson, returning its corpse to American jurisprudence to allow the government to do whatever they want.
Well, and here's another comment that I see a lot of people making, and it's an insightful observation. It won't be big government that's going to uphold Jacobson. It's going to be private enterprise. It's going to be airlines, transportation, companies saying you can't come in unless you show me your vaccination. Then the question is going to be taking those entities to court and having the court say, no, they can't have this as a prerequisite to anything. But I mean, what are the chances of that happening?
Then it's a different kind of legislative reform. Yeah, and to operate on the legislative front, state legislature front, congressional front, but at minimum keep the government from being able to force it and coerce it. And then the next step is try to take legislative reform to make sure that private enterprise can't substitute for it. I mean, there are certain privacy limitations and other provisions, non-disabled, discriminating against the disabled, non-discrimination provisions that might be applicable. I mean, I know I'm going to be bringing suing some of these private enterprises for violating ADA and other laws in relationship to their mask enforcement. So the same provision might also apply to vaccinations. But I think it will probably lead to a right of privacy being expanded to making it a legislative protection from private enterprise in time. It is probably going to be needed if they go down this route.
Interesting. And now Charlie Foxtrot says, Charlie Foxtrot, for anybody who doesn't know, those are the international code for the letters C and F. New York attack on religion makes sense that churches don't pay the state sales tax, etc. So I've heard people say, I don't care about the persecution or the differential treatment of churches and synagogues because they don't pay taxes. So the first thing I say to that is there's a historical reason why they don't pay taxes. The second thing I say to that is there's a bunch of other entities that have good tax agreements with the government that you may not want to start getting into this selective, disparate, harsher treatment. And I don't see that as a justification in any event, even if I think they should pay taxes. But what's your take on that, Robert?
If you have the power to tax is the power to destroy. So if you give them the power to tax an organization for political advocacy or religious expression, you give the state the power to destroy both. So that's why that's never a good idea.
That, and yeah, I mean, it's the other thing is the attendance for the attendance and financing for churches. From what I understand, is you tax them, they will effectively no longer exist, and you lose a very important element of the history of your country. What have we missed tonight? Have we missed anything?
I think that's the main ones that I recall. Some people asked about Section 230, but that would be sort of a broader conversation, broader topic for later.
The Candace Owens now that, let me see who we got here actually. Barnes can't possibly be naive enough to think they'll ever let another Trump scenario happen in the U.S. again. Does he? Especially with the measures they've taken to remove him.
There's just limits to what the system can do. The fact they can steal this election, their ability to suppress the population into perpetuity, just study the history of 1775. That's what the British colonialists thought when they suppressed aspects of the American Revolution the first time around. Didn't work. So the history is enough people take action and you're going to make a difference sooner or later. So the idea that the system can completely suppress and oppress its population into perpetuity is just not related in history. There's just as many examples of successful revolution as there is the suppression of political populism of different kinds. And through at least American history, populists usually bounce back stronger. So the idea that you can just, they thought they were going to crush it in this election. They thought this was going to be outside of the margin of fraud. So, the people poured out anyway. So now that the fact they have to expose themselves in the election process on top of everything else is just going to further undermine them. And like I said, a record number of people believe this election was the product of fraud in a presidential election. And that number is growing and deepening, which is also historically unprecedented. So at least in modern times. So I don't see it as, I understand how people are like, if we don't win now, it's all over. I'm just saying that's not what history says. History says Act 2 doesn't end the act. Act 3 does.
And always with the caveat that it's through peaceful democratic means. 78 million people thinking that this was unfair. They will find a way they'll have their voice one way or the other. I tend to agree with you. You can't.
Yeah, look at just the state judges that started to fold over this week. Yeah, okay, it wasn't the final judgment, but you still got Michigan judges saying there's serious problems, Supreme Court judges, Pennsylvania judges saying there's serious problems, state legislators willing to hold hearings. These are all things that just the week before hadn't happened at all. So the idea that, oh man, if we lose this battle, no war can ever be won is a defeatist approach that you don't have to take. I understand why people think, well, if we don't win now, look at how, maybe they'll rig the system forever. I understand that. I understand that mindset. I'm just saying history belies it, especially if people continue to take productive, constructive action.
We might we need a vlog breakdown of Jacobson. It's often alluded to, but I don't think I've ever heard an explanation. That might be something for a quiet day. I've been saying there are a few things that we have to do, Robert, that we've been putting off for a quiet day, which is never coming. Thank you, Viva Barnes, for doing these weekly streams. It seems that in large part, truth telling is the domain of individuals and not corporate interests, whether business or government. I tend to agree. Politics ruins everything. Politics is just the struggle for power. And you have the bigger the enterprise, the bigger the struggle for power and the balancing of all the interests. And it's just, it's the way it goes. Now, hold on. I saw Cleopatra had another super chat right here. Boom. Read the vaccine. I can't take it. 2-time cancer survivor. What are my chances of ever cruising or flying overseas again?
Well, the other thing is, think about this. How exactly are they going to be able to get proof of that? So, they're going to create a unique black market is what they're going to do. It's like a futuristic movie. futuristic film, right? Where you're getting the fake this document or that document so that you can get through the system. That will take off overnight. There's plenty of people that aren't going to go along with this. So to the degree this was Bill Gates' agenda or objective all along, he's underestimated the degree of opposition. In fact, there are more people opposed to forced vaccines now than ever before. So they've actually increased doubt, not increased confidence. And that's where at the darkest time of Valley Forge, it looked like everything was lost. And then a year later, the most successful revolution in Democratic history took place.
And Jay Mill, I saw this before and I missed it. Sorry, Jay. Jill Stein's case won access to source code on voting machines in Wisconsin. Will it come into play?
It could. I mean, I think the hard part is where Sidney has sued, they may dismiss everything, and maybe she'll still have a chance to go to state court to get remedy, but it might be a little tricky based on timing issues. But some of the election contests can ask for that kind of information and get it. And I still have up on the, and I'll maybe I got to repin it, but on the locals board, an exemplar of what an election contest would look like. And I know some members of locals have already filed various election contests. So the more the merrier. Again, it's not my legal advice to do so. It's just an exemplar to do as you see fit. But to have fun with it. And at least take a shot at it. Let's democratize the legal process. Let's democratize the election contest process. People start asserting their rights is how they make those rights meaningful.
And we'll see so what are we waiting for this week? There's going to be another one of those Pennsylvania type hearings before the legislature in which state?
Well, there's going to be a bunch of stuff. So there's going to be an evidentiary hearing on election contest issues in Nevada. There's going to be a public hearing in Arizona on Monday. That's Arizona legislative supported. There's going to be appeals to the petition for cert to the Supreme Court in both the federal case out of the Third Circuit by the Trump campaign and the Pennsylvania Supreme Court case ruling. I'm trying to assist those folks in different ways that they can get it before the U.S. Supremes. Again, there's plenty of ways to get it before the U.S. Supremes. It's just whether they want to take action or not. But you can present it in the most effective political manner that reminds them of all the different times they have. Like suddenly voter dilution is somehow no longer something you have standing for. The different ways counties count votes somehow doesn't matter. Well, that wasn't the case in Reynolds v. Sims. That wasn't the case when they struck down the Tennessee system for apportioning state representation. Then they said any voter could sue based on what some other county was doing. So you notice these cases somehow magically don't appear in these courts' rulings. These courts were intellectually honest. They would deal with those cases. If they're going to do an uncivil law analysis, they would say, here's what it is, and here's where I disagree. They don't because they're frauds, because these are intellectually dishonest opinions. So challenge them, contest them, expose them. So you're going to see probably petitions for cert filed this week before the United States Supreme Court. There's already other cases pending before the United States Supreme Court related to Pennsylvania. So you'll have like 3 cases just before the U.S. Supreme Court in Pennsylvania. You'll see election contest filed in all of the states that are close, that have not yet had one. You already had one in Arizona. Probably will have a hearing this coming week in Arizona on that election contest case. Probably will have a hearing on an election contest case filed in Georgia. May have one in also in Pennsylvania. In Wisconsin, the Wisconsin Supreme Court may schedule this week a hearing on the petition for original petition to throw out the election due to issues related to people not being indefinitely confined, voting as if they were. That number went from like 14,000 to 167,000. And remember, folks, COVID was not an excuse in Wisconsin for that. Amazing. And last but not least, in Sidney Powell, they've scheduled a hearing for Friday in Georgia.
Okay, it's going to be one heck of a week then. Oh, and by the way, Joseph Johnson, thank you very much for the support and the super chats. Wants us to look, and I say us, I think everybody, have a look at the Wayne County website. Joseph, you don't need to do another super chat. Just post the link down there and crowdsource the knowledge. My name is actually Charlie. Just because they did it doesn't mean I agree with it. Charlie Foxtrot. Okay. So that's going to be a big week. So we're going to have a big week stream next week if we don't have to do a midweek stream, but we'll see about that. That might not be feasible. What else? I think we should probably wind it up. It's been one heck of a dense stream. Robert, I'll give you the last word. Assure the people, give them some optimism at the end of the day with, first of all, book recommendation, movie recommendation.
Sure. So Kevin Phillips, 1775, gets into a great history of the things that made the revolution possible in 1776. and all the reasons to have doubts or questions or reservations. Trust me, in 1775, if you existed, you had only known royal rule for every ancestor going back thousands of years. So the idea that you were going to overthrow it and have a democracy and a constitutional democracy, that was crazy talk. And yet a year later, that's what the revolution helped birth. So people should look at history to remember that that even when it seems as dark as possible, there's been plenty of times in history where the light was a lot brighter at the end of the day, where Act 3 really did lead to the restoration of the hero, and that may come in multiple forms. It may come now, it may come later, but that doesn't mean it won't come, no matter what happens in the forthcoming future. And you can see the good show that's on HBO, Undoing. I think its finale is tonight, about different ways so there's different aspects of that which are interesting for law, which I'll do a breakdown on locals. Try to take a look at TV and movie series and books from a legal perspective and a political analytical perspective, but give it the legal angle of what's credible, what's not, what you can learn from the legal system about it, what's not as useful. And we'll do that at the local site for those subscribers. So, my view is, remember our history, to remember that a lot of people have seen much darker nights and that have only been foreshadowing for a much brighter morning.
Okay, very nice. Andy Pearson says proof of vaccination would be a HIPAA violation. Probably accurate statement. Okay, you know what? Let's just leave it on the optimism, Robert. Everybody, thank you very much for tuning in. Another amazing stream. We're going to do it again next week. We'll have even more to talk about and more results, and we might know how Act 3 is shaping up based on the evolution of this week. So that's it. I mean, guys, enjoy the rest of the weekend. Stay optimistic, and at the very least, if nothing else, stay informed and share the information around so that people around you are informed. And that is it. Enjoy the rest of the weekend. Thank you all for coming, and we'll see you soon. Robert, stick around. We'll say our proper